6.10, public hearing continued from October 21st, 2025, consideration of appeal PL 25-198 of Planning Commission's approval major use permit PL 2568 for UP 2309 Poverty Flats Ranch, Kurt and Robert Barthel, location 10535 High Valley Road, Clearlake Oaks, APN 006000422, Appellant Maria Kann and Associates. And community development will be starting out. Lloyd?
Thank you, Mr. Chair. Your board may want to consider swearing in witnesses. This is a public hearing, an appeal hearing.
All right, Johanna?
If you're here and you're going to provide testimony, or just you might speak or you might not, stand up. If you're in Zoom and you're going, raise your hand in Zoom if you're going to speak on this item. All right, and we got Donna in Zoom. Okay, do you solemnly swear that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth? Thank you.
Good afternoon. Maria Turner, Community Development Director. You have before you an appeal that has been continued from previous meetings. I will turn it over to our planner, Max Stockton. We also have Senior Planner Michelle Iris here to help support staff responses, as well as representatives from both the appellant and the permittee. And I will turn it over to Max in one moment.
Good afternoon, supervisors and Chair Crandall. My name is Max Stockton. I'm an associate planner with CDD. The applicant, their consultant, appellant, and associates are present in chambers. Both applicant and appellant have requested the opportunity to present following staff's presentation today. This project was approved by the Planning Commission on May 22nd, 2025. While the Planning Commission identified concerns related to High Valley Road, a county-maintained roadway, they ultimately approved the project by a 3-to-1 vote, with Commissioner Brown absent. An appeal of the Planning Commission's decision was filed by the appellant on May 28th, 2025. The appeal application is included as Exhibit C. All public comments received are included for the record. The appellant brought forth claims of illegal grading and land disturbance. In 2022, following the Mendocino Complex fire, the applicant submitted a grading permit to facilitate the clearing and maintenance of the existing fire break, along with improvements to the access road and to meet Public Resource Code 4290 standards. Permit number GR 22-12 was issued on April 18th, 2022. Followed by minor trenching conducted in accordance with the well permit approved by Environmental Health on May 22, 2022. In June of 2024, all grading was inspected and confirmed to be complete in compliance. The appellant brought forth concerns pertaining to road safety. High Valley Road, a county-maintained road, is a prescriptive right-of-way. The road is open to the public. Public Resource Code 4290 requirements must be met on interior roadways of the project parcel, with county-maintained roads not requiring alterations by the applicant. The applicant has proposed interior roadway improvements on the project parcel as required by Public Resource Code 4290 and 4291, and has proposed the use of box trucks for delivery services rather than the use of semi-trucks for the proposed cultivation operation. Additionally, staff measured across portions of High Valley Road around the U-curve, as seen in these images, from the shadow line to the edge of the road. The remainder of the dirt portion and all were measured conservatively at 18 to 30 feet, with a variety of turnouts and portions of the road measuring in excess of 30 feet wide. Biological, hydrological, and archaeological studies were prepared for the project in compliance with all requirements. However, staff inadvertently omitted the botanical survey dated May 8, 2024 by Greening and Associates, LLC, from the Planning Commission's agenda packet, which is attached as Exhibit D. The botanical survey was included, reviewed, and referenced in both the draft initial study and staff report. Staff also clarified this at the Planning Commission hearing. The appellant does not provide specific details regarding environmental impacts they feel were not adequately assessed within the appeal application. However, in compliance with CEQA, a draft initial study mitigated negative declaration was prepared and circulated from January 9th, 2025 to February 7th, 2025. Mitigation measures were identified for aesthetics, air quality, biological resources, geology, soils, hazards and hazardous materials, hydrology, water quality, noise, transportation, tribal cultural resources, utilities, wildfire, and mitigation findings of significance. All impacts were determined to be reduced to less than significant with mitigation measures implemented. All CEQA regulations have been met, and the draft initial study was adopted by the Planning Commission on May 22nd, 2025.
Just for clarification, instead of the mitigation things of significance, it's actually the official title is mandatory findings of significance, and that was included within our analysis.
The appellant brought forth claims of potential inconsistencies with general plan, land use, and zoning policies. Chapter 3, Land Use, Chapter 7, Health and Safety, and Chapter 11, Water Resources of the General Plan were reviewed, as well as the Shoreline Area Community Plan. Article 7, Rural Lands, Article 27, Uses Generally Permitted of the Lake County Zoning Ordinance were reviewed. A detailed analysis of conformity within the general plan and zoning code is included in the staff report. The proposed use of commercial cannabis cultivation is a permitted use in the rural lands zoning upon issuance of a major use permit. The project meets the development standards, general requirements, and restrictions as specified in Article 27. And the applicant has submitted a property management plan outlining compliance with all regulations pertaining to cannabis operations. Staff must analyze projects in conformance with existing code requirements and regulations. As discussed in detail throughout the staff report and associated documents, the project meets all regulations related to development and siting. Staff recommends the board deny the appeal, upholding the Planning Commission's approval of the project. And that's what this slide here says. Staff would like to clarify that the initial study number was uploaded and circulated for public view as initial study IS 23-20 and not initial study IS 23-29 as written in the staff report and carried onto the board's memo provided for hearing today. And that concludes our presentation.
Brad?
Yes,
Brad,
just
and then I'm going to go and then you.
before we get further into the item, I wanted to disclose that for 20 years I worked at the same agency as Mr. Bob Barthel. He retired 16 years ago, so I probably worked with him between 1989 and about 2009. We were at different agencies inside the city of Lakeport, but I just wanted to make it known that we did know each other. We did interact in a professional capacity related to the joint work of Public Works and Lakeport Police during that time, but I had no personal relationship with him outside of work and didn't associate with him outside of work. So I just wanted to make that disclosure and also make it known that I did go personally to the project site a few days ago and look it over because I felt it important to understand what it looks like, see the roads, see the location where the project was going to exist. So thank you.
And a quick question. I'm pretty sure I know the answer, but I'm going to ask anyhow. When the grading was done, was there cultural monitoring there? And I know that there was contact with Cliff Moda, but there wasn't further contact with them as well. Is there a reason why?
I can answer that, Michelle Ayers, Senior Planner. There's two sort of separate grading activities that we're talking about. The ones that were completed for the fire break and that GR 2212 were exempt from needing further review. And the information that you see in the record related to monitoring and with Clifford Moda is related to the grading that would occur if
That will occur.
Yeah, if the permit should be approved.
Okay, and so that's what he's asking for, future knowledge of that, so he can have monitors there in case that takes place. That's what that's referring to. It's different.
Correct, and it is included as a mitigation measure, and the applicant has also entered into an agreement with that said tribe, and they can speak to that more.
Okay, all right. Yeah, I was just making sure. If you probably don't know, we have a TIPO group that meets monthly. We're doing our best to work more collaboratively with tribes. I think it's very important that we keep these things intact or do our best to make these agreements, or at least ensure that folks that are doing projects are at least, in this good faith effort, because, it's been a long time and we've been dealing with, we don't want to have to go back in time where we're not contacting them or keeping that ongoing consultation if possible. I know that there's specific CEQA guidelines and there's also exemptions and whatnot, but at the same time, good faith makes a big difference. And I don't want to do that work and jeopardize it. And we have a hard time getting enough trust from these governments, and we just wanted to make sure I asked that and put that emphasis on it as well. Supervisor Sabatier?
Yeah, I apologize, Chair. I'm wondering if I can get a minute recess, please.
Yes. Okay.
I need to have a private conversation with County Council.
Okay. Well, we'll take 5 minutes.
No name.
All right.
It was good. I tried one.
Is it mint chocolate?
We're coming back from our break.
Peppermint on top, so it kind of gave it away. It was really good.
I think they're looking up something right here.
You ready?
Yeah. We're ready. Do you all need some time, or?
No, we're
Oh, okay.
fine. Go right ahead.
Okay. Go ahead, Supervisor Sabatier.
So I wanted to have a private conversation before asking something that might be embarrassing or whatever in public. These are de novo. And so we are looking at the project as a whole, not just the appeal, the concerns, and the response to the concern. So what I've asked is, are we prepared to do a full presentation on what the project is so that we can really check the box that we are fully informed in making the decision that we plan to make today? I want to ask the board if you wish to have that full presentation. It's not up to me to control that and make that happen. I would feel more comfortable by having the full presentation as well as the appeal concerns and the response to the appeal. Just because, again, these are de novo. We are not just approving the concerns and the response. We're approving the entirety of the project.
I thought,
I'm good with
yeah,
that.
that's what we're doing. I just had a question because he talked about grading, so I don't know if that played into what.
No,
okay,
not at all.
Okay.
Not even close.
Yeah.
And we are prepared to go ahead and give that presentation.
Okay.
It was
And we're happy to make that,
Okay. I was like,
we're happy to make that as a standard part of our appeals going forward. We just never have done it before, but it's fine.
okay.
Well, it might take a moment. Right. We do have the PowerPoint slides that we presented to the Planning Commission that we're happy to present to the board. We're just transmitting it over a sludgy cyber system here.
Just got it.
Excellent. And Johanna will pull that up, and we'll start as soon as it's ready. Looks good to me, yeah. All right, I will turn it back to Associate Planner Max Stockton. Cancel. Yeah.
50-50.
Hello again. I'm going to continue from this slide here, which is the second slide. And you got it. Nope. Go back. All right. So this project proposes a total of 5.69 acres, which is 247,800 square feet of outdoor canopy area, and one Type 13 self-distribution license. The total acreage for the parcel is approximately 196.7 acres. Next slide. In vicinity of this project, to the north is mostly undeveloped, east is mostly undeveloped, to the south is farmland, and to the west is commercial cannabis farm and undeveloped, with the project site approximately 2.5 miles to the nearest community growth boundary. Next, please. Zoning for this project is rural lands, as discussed previously, with the full zoning being RL for rural lands, WW for waterway, and SC for scenic combined, and is within the Shoreline Communities Area Plan under Supervisory District 3. One thing to note in this imagery on our screen is that the blue box is approximately where the cannabis will be grown, is proposed, and the yellow lines above outline the scenic combining distance from High Valley Road, showing that the proposed cultivation will be outside of that scenic combined corridor. The site location is approximately 5.5 miles from Highway 20, and the project parcel has a variable topography with a series of ridge lines and valleys. The proposed project locations are located in areas that are between 0 and 30% slope. .69 acres are proposed of outdoor canopy located within various cultivation areas. Also within each of the cultivation areas are proposed above ground propagation. Next, please. Existing uses. The property is developed with interior access road, an existing security gate, perimeter fencing, and 1 groundwater well with permitted pump house, 2 permitted shipping containers, 2 tool sheds, an old hunting cabin, and 8 water tanks. Next, please. Under project analysis, as previously discussed, the project has been reviewed through the Lake County General Plan, Shoreline Community Area Plan, Lake County Zoning Ordinance, and state regulations. Next, please. The general plan goals and policies reviewed included Chapter 3 for land use, Chapter 7 for health and safety, and Chapter 11 for water resources. Yep. The project as proposed is for outdoor commercial cannabis cultivation. There are no mapped areas of farmland or local importance or farmland of statewide importance at the project site. The proposed project is not located within a farmland protection zone, and greenhouses are not required. The applicant has provided a water availability analysis and drought management plan and is required to adhere to the State Water Resource Control Board Cannabis Cultivation General Order requiring runoff to be retained on site to mitigate impacts. Next, please. The project is an allowable use with a major use permit in the RL zoning with the RL zoned properties per Article 27.11, uses generally permitted, and far enough from High Valley Road as to not impact the scenic combining district. Next, please. As previously presented, there are many aspects that were evaluated for this project, including aesthetics, air quality, biological resources, cultural resources, geology and soils, hazards and hazardous materials, hydrology and water quality, noise, transportation, tribal cultural resources, utilities, wildfire. Next, please. The California Environmental Quality Act looked to mitigate A drafted mitigated negative declaration was created to meet those needs of CEQA and the environmental determination for this project. All identified impacts can be reduced to less than significant with mitigation. And public comment period occurred between January 31st, 2023 to March 2nd, 2023 for the request for review RFR process. Mitigations are outlined in staff report, draft conditions of approval, and attachment of the draft initial study mitigated negative declaration. I apologize, I haven't done this in a while. Next, please. The Elam tribe contacted former staff involved in the project via telephone, and staff coordinated a meeting between the two parties, applicant and tribe, to come. An agreement was not reached between the applicant and tribe, and staff concluded that consultation that same day. Although we clarified that previously at the beginning of this presentation, that the tribe and the applicant have been in touch and have come to an agreement at this time.
I wanted to just add a little information to clarify AB 52 requirements. A request by a tribe for consultation of a project is a meeting between the two governments. It takes place in our office. It is not the site visit. We do not require that the applicant enter into an agreement with a specific tribe for monitoring. Neither of those are part of the official consultation process, though historically they've tended to get conflated. So I just wanted to make sure that the board is very clear that when we are in compliance with AB 52, it means that we are having a consultation meeting with the tribe requesting, so they have the opportunity to come meet with us and tell us what known sensitive areas or tribal resources might be in that project area. When they do make a request to join us on a site visit, we do everything we can to accommodate that request, but that is not part of official AB 52 consultation. So when it says that it was concluded on the same day, to me what that means is that we did hold that meeting with the tribe so that they could bring us their information and concluded to that consultation at that time.
And that also that can continue because meaningful consultation means that they would go back and forth, so.
Correct, but it does not include negotiations regarding site visits and specific agreements with, or monitoring agreements with a specific tribe.
I just bring up meaningful because I hear that all the time when we have other meetings and they say, well, they only met with us once. They didn't continue meaningful dialogue. And so that's why I added meaningful.
Meaningful dialogue is very important to us. But during AB 52 consultations, we stay in compliance with state law.
Right.
Staff has included 2 tribal cultural resource mitigation measures regarding tribal sensitivity training and any resources encountered.
Do you mind if I interrupt and ask a quick question? April 9th, 2020, is that date correct? Because I thought the project was only submitted to you guys in 2023. I was just kind of curious as to where that date came from.
Yeah, that's a good question. It's right here.
Johanna, is it possible to go back a slide?
Yep.
Yeah, that's, you're correct. Thank you. It was sent out on December 20th, 2023.
Thank you.
Total projected water use for cultivation operations is 11.2 acre feet annually, or 3,650,000 gallons of water per year. A drought management plan is included with the hydrology report as attached to staff's reports and outlining water conservation measures during the declared drought emergencies. Next, please. The project property is accessible via High Valley Road, a county-maintained road, approximately 0.42 miles off of the driveway. The applicant's driveway is known to be federal lands. The applicant, Kurt Barthel, has signed an indemnification agreement for transportation of commercial cannabis across federal lands. Next, please. Following the Mendocino Complex fire, a grading permit was submitted for clearing and maintenance of the existing fire break, along with improvements to access roads to meet Public Resource Code 4290, 4291 standards. Grading permit GR 2212 was issued, and the inspection confirmed that the grading was conducted in compliance with grading ordinance. Next, please.
If we could go back one slide, please, Johanna. I just wanted the board to know that staff has conferred with County Council in the past regarding driving over these federal lands. We currently also have 7 other approved permits that have a similar crossing over federal lands that have all successfully been granted state licenses.
Within 1 mile of this proposed project, there are 0 pending projects. Within 3 miles of the project, there are 2 pending projects and 2 approved projects. Next, please. And before you are the recommendations to the Planning Commission, and those recommendations were to adopt mitigated negative declaration, initial study, IS-23, and the typo as mentioned previously was that is IS-2320 for use permit PL-25-68 with findings found in the staff report. Also, to approve the use permit PL-25-68 for UP 23-09 with the proposed conditions of approval and with the findings in the staff report. And that concluded that presentation for the Planning Commission.
All right. Okay. I'm not hearing any questions, so I think the appellant. What's that? You need a couple minutes? She's going to try and pull up your.
You want me to?
Oh, okay. We'd like to give one of these, 1, 2, 3. One's for Johanna and one's for each of the board members, please.
Thank you.
Thank you. Oh, you'll want to go to PL 25198 Master Slide Presentation Part 1. Well, are you going to do the entire thing at one time or by part? she had trouble with the big one because it crashed her computer. Do with part 1 and then part 2, because I think we adjusted our speaking notes to have it broken up. Correct. Part 1, please. Well, it made me crash quite a bit, so. That's Max.
Yeah. Let's take a 5-minute break while she works on getting this. One second, I think. There we go. All right, so before we start out, we're going to go ahead and move forward. You got everything lined up for this presentation? And we're gonna do our best to keep it to at least 15 minutes. We can bleed over a little, but we're gonna do our best to stay on target with that, okay? And we'll if it bleeds over, we'll do what we can, but yeah. I understand. Yeah.
Beautiful country. Okay, now, which button do I push? Just the arrow, the right arrow? Okay. Okay. Good afternoon, Chair Crandall, Vice Chair Rasmussen, Supervisor Pyska, Supervisors Owen, and Supervisor Sabatier. My name is Maria Kann, and I'm the appellant in PL 25-198 concerning Poverty Flats Ranch UP 2309-2320. We are here today to present our fair argument for why your board should grant this appeal and reverse the approval of UP 2309 as presented, because the whole of the project, as SEQRA requires, was never properly analyzed. Today, we will focus on the central issues that make this project infeasible, unable to move forward, and unable to comply with county, state, and federal law. We welcome your questions at any point. We will show you where the project fails to meet federal right-of-way requirements, Lake County Zoning Ordinance Article 51, Public Resource Code 4290, Title 14, and CEQA's mandatory procedures. Our appeal contains 12 chapters with dozens of violations. We won't cover every detail, but the next 13 slides will show that each chapter contains at least 3 fatal defects, any one of which satisfies the fair argument standard needed to grant the appeal. I've lived in High Valley for more than 25 years. In that time, I have watched forested mountainsides and a pristine valley floor slowly stripped of their natural integrity, first by vineyards and more recently by cannabis operations. I was forced into civic action in 2021 when I witnessed my beloved valley severely damaged by a project that moved forward without effective environmental protections. Since then, I have been speaking out against similar high-impact developments concentrated on High Valley Ridge. What I have learned is that this process enabling these projects is fundamentally flawed, and the environmental safeguards meant to protect this landscape are not being applied. This is not about cannabis. It's about feasibility, legal compliance, and the obligation to evaluate projects truthfully. It is also about the safety of High Valley residents who depend on a single escape route, the preservation of tribal heritage that cannot be replaced, and the protection of a watershed that sustains wildlife and communities downstream. I am not anti-development. Development can coexist with stewardship, but not all locations are suitable for development. High Valley Ridge is one of those places. It carries unique constraints, an undeveloped and a substandard road that crosses federal land, extremely high fire danger, undocumented but historically certain tribal cultural resources, and a wildlife corridor used by numerous species. This appeal is an effort to protect what remains of a place that is extraordinary archaeological, cultural, hydrologic, biologic, and ecological significance. I stand here with deep respect for the history of this land, including the Elam and Camdot, Pomo descendants who lived, traveled, and gathered along High Valley Ridge for thousands of years. Their cultural imprint still lies just below the surface. It is our shared responsibility to ensure it is not erased by grading or development carried out without transparency or oversight. Today, we will show that Poverty Flats is not simply flawed. It is the result of a CEQA process that was never neutral, never complete, and never transparent. And because CEQA is fundamentally a truth-telling statute, these defects matter. CEQA requires the county to evaluate the whole of the project, not just the convenient parts and not what remains after unpermitted work has already altered the land. Yet that is exactly what happened here. Before any permit inquiry and before SEQR review, the applicant cut new roads, removed trees, graded through stream beds, installed culverts, drilled a new well, trench cut to cultivation sites, and graded ridgelines and slopes. These are not minor brush clearing activities. They are substantial physical changes that SEQR requires to be disclosed before they occur. When this unpermitted work is folded into a ministerial permit, when steep slopes are relabeled as flat ridge lines, and when the environmental baseline is reconstructed around the altered landscape, CEQA is not being followed. CEQA is being bypassed. High Valley Ridge is a place worth protecting. This ridge is more than a location. It is a cultural landscape. Generations of Pomo families moved across its contours. Their high ground winter camps remain embedded in these slopes. Their routes once connected villages and valleys. Your own county documents show that none of the grading, clearing, and trenching was evaluated for impacts to tribal cultural resources, despite this being a historically inhabited and culturally sensitive area. This was not government-to-government consultation as required by AB 52. Consultation was left to the applicant, something CEQA does not allow. Elam Tribal Historic Preservation Officer has confirmed that they were never consulted. At that point, mitigation measures like TCR1 and Bio2 are meaningless because grading has already occurred. We cannot protect cultural resources retroactively. We can only protect them by telling the truth about the land and evaluating impacts honestly. And with that foundation, I would like to introduce Tom Lasik, who will begin with the first major issue, federal land access and the BLM indemnification problem, an issue that goes directly to whether this project is even legally feasible.
You can stay there and drive.
Okay. Oh, I guess I didn't even go through. Well, I'm just going to run through these slides. They simply show the defects by chapter.
Yeah, thank you. Thank you, Chair. Thank you, Vice Chair, members of the board. I'm going to talk right now about BLM and BLM identification. Very quickly, just sort of as a guiding post as I go through this, SEQA requires lawful access for use. Without lawful access for use, the project is not feasible. So that's one important thing. Unfortunately, we'll also be talking about misconduct. SEQA wants not only a fair, impartial, and unbiased hearing, but also a fair, impartial, and unbiased process. And when the process isn't fair and impartial and unbiased, that's cause for a permit or a permit to be denied and an EIR required. It's about making sure the process is fair, and you're going to find out that there was a considerable amount of discussion just on this topic that was quite prejudicial. And the first thing I would like to point out to that point, if you refer to your legislative letter to the board that was provided by CDD, you will find no mention of this topic, even though it was significantly discussed in the Planning Commission hearing. It is not appropriate to cherry pick those things they want the board to hear and those things they don't want the board to hear. Furthermore, the draft of that legislative letter was put out in July, before any of the documentation that we provided was even looked or discussed. That's a foregone conclusion that makes this more of a perfunctory activity instead of a legitimate hearing when those things occur. It makes it difficult for you to make an informed decision when that kind of behavior occurs. So we'll go right into it. The next slide, real quick. Does the applicant need to cross federal land? The answer is yes. They have to cross the Berryessa Snow Mountain National Monument. It is federal land under the stewardship of the fine people at the U.S. Forest Service and the BLM. It is federal land. Go to the next slide, please. Next question is, do you need permission to cross federal land? The answer is yes, and this is worthy of distinction because we're going to touch on this later. Federal lands operate differently than other lands of the state. Other lands of the state operate on what's shorthand as a doctrine of what's called open and less closed. You're authorized, approved, allowed, permitted to cross regular lands. We don't need a special permission. That is not the case for federal land. Federal land operates on the opposite doctrine. It's closed unless open. You are not allowed, you're not permitted, you're not authorized, you're prohibited for conducting commercial activity across federal land unless you have explicit permission from the federal government. In the case of the BLM, that's in the form of a right-of-way grant or a special use permit. Without that, you're not authorized. And if you cross the land without that authorization, you could be cited for trespass, which is a crime that's recognized by both the state of California and the federal government. It's not about cannabis, it's just basic property rights. Next slide. The next question is, what if there's a prescriptive easement? Well, does that help? Well, no, it doesn't help. You see, prescriptive easements don't work that way, and they certainly don't work across federal lands. At the most, in the case of Mr. Barthel, he would be allowed lawful passage, but not for a use that has not been authorized by the federal government. When the federal government says no, no means no. So what does the federal government say? The federal government says, next slide, they say no. Twice the BLM has informed CDD that they cannot authorize this use across federal land because it remains a crime. Now that crime that they're talking about is possession with intent to distribute, which is a federal felony, which exacerbates the trespass from a misdemeanor to a felony, up to $5,000 fine and a 5-year sentence. So at this point, we are pretty much have made the fair argument that they don't have the legal authorization that's required by CEQA. Unfortunately, we're going to go further because, well, CDD has gone too far on this. This is a copy of the letter from the BLM. Next slide. The problem is if you issue the permit anyway, when you know that the applicant has no choice but to break the law, then you've crossed the line. You're no longer doing neutral administrative work. You're now aiding and abetting in the furtherance of that trespass, which itself is a crime. And that's not appropriate. You're also exposed the county to civil liability in the course of willful misconduct, willful negligence, and abuse of discretion. Next slide. So why is this happening? And the reason it's happening is because about 5 years ago, the CDD came up with something called an indemnification agreement. Its intention was to hold the county totally harmless for all liability in the event someone like Mr. Barthel is crossing land and does get cited, and that the county would then be held totally harmless. And there's a pattern here because the BLM has been issuing these letters for years, and the letter comes into CDD, and the CDD ignores the letter and issues the permit anyway. And so it's a pattern. This is not a one-off. Next slide. This is a copy of the indemnification agreement that they're required to sign. And as a point of record, this was not provided in the Planning Commission hearing. As Mr. Stockton mentioned, he said that they signed it. Through the PRA request, we were told we were not going to give a copy until he signed it. So apparently he never signed it. Next slide, please. This is a list of other projects where we found that the BLM has provided a notice because not allowing crossing across federal land. And so this is not an isolated incident. Next slide. So does this identification agreement resolve the issue? And the answer is no. First of all, it doesn't address the underlying CEQA requirement of lawful access. This does not remedy that. All it does is shift the liability away from the county, or tries to shift the liability away from the county and onto the applicant. Well, does that work? Well, that doesn't work either, because first of all, there is no indemnification agreement on the planet that protects anybody or shields anyone from criminal activity. That is not what indemnification agreements are for. They're for civil liability. And as far as civil liabilities are concerned, it doesn't work for that, because as soon as you issue the permit knowing that full well there's no choice but to commit the trespass, then you have created the willful negligence and willful misconduct that's in the indemnification agreement that renders it void and unenforceable. So essentially it self-destructs the instant you issue the permit. Go to the next slide. Now the Planning Commission was all over this. They saw this was a problem. They saw it was an issue. They saw that innocent people could be harmed. The driver's not protected. Why is the county getting involved with this? Why is it this serial criminal thing going on? And it made no sense. Unfortunately, there was a significant amount of prejudicial misconduct that was performed during the Planning Commission hearing. And there's a pattern of that misconduct because these same lines were used in other hearings when this same issue came up. Next slide. First, they weren't given a copy of the indemnification agreement, so they had to rely on the interpretation, the creative interpretation from county council as to what it was about. And in this hearing, as well as the Lou Farms hearing, it was trivialized. It was, well, this is just a thing we do to make sure people know that it's still a crime. It's just something that you can go to the next slide, I think. It just wants to make all parties involved, just make sure that they know what's going on. It's not a fact sheet. It's not an FAQ document. It's not a reminder post that you put in your kid's book bag before you send them off to school. It's a contract. It's a contract they're required to sign. If they don't sign it, they don't get a permit. It is more, you just can't go around saying, oh, it's just this thing we do. Next slide. The next thing that they said, there's no distinction between this and federal lands and other lands of the state. Same thing was said in Lou Farms. In fact, in Lou Farms, they even said, well, the state sanctions it and the county is just following the state. Well, as I pointed out earlier, there is a distinction. It's night versus day. It's open unless closed instead of closed unless open. It's yes, you can cross and don't need a permission slip versus no, you absolutely do need a permission slip, otherwise you're in violation. And the state doesn't sanction it. The DCC, their fact sheet makes it abundantly clear. Do not possess or use cannabis on federal lands such as national parks, because it remains a federal crime. So we have the federal government saying, don't do this. We have the state saying, don't do this. But here we are. Next slide. Well, no, this slide's good. Then when they were told that you don't have, that the planning commission and then the board neither have the authority to make a decision on this issue because it's not within inside the property lines. That they can only make the decision based on what happens inside the property lines. That is an improper constraint. It is not allowed. The Planning Commission and the board absolutely have the authority, and in fact, SEQA requires the board to look at the whole of the project. That includes those things that happen outside the project, such as deeds, easements, rights of way, such as 4290, such as traffic safety, cumulative effects, erosion, on and on and on. It is not just what happens inside the property line. Next slide. And then they were told, well, if there's a risk, don't worry about it. You know, it's just a matter of
15 minutes, so if we can continue and start to wrap up.
Okay. We have a variety of these, and again, there's been quite a pattern. Then we were told, continue on. This is just a list. Lake County is an outlier. I met with the BLM. The BLM is very frustrated about this. And they said this is the only county that does this. They don't have this problem with any other county. Mendocino County responded back to me and they said, yes, we don't touch it. If an applicant cannot get to the property without crossing federal land and can't explain how, they don't issue a permit. We then have omission, and this is where it becomes a concern because Director Turner said, well, we've issued several other permits and they've had licenses to the state. The problem is this was not mentioned in the MND at all. And the pattern is none of those other ones is it mentioned in the MND. There's no mention in the federal lands, no mention of the BLM, no mention of the BLM letter, that it's not allowed, that it hasn't been authorized, and that it's a crime, and no mention of the indemnification agreement. So we got additional evasion and omission. And then, the last thing on this topic is you haven't been informed. This is a contract. According to the state, it's the board that has the authority to enter into contracts. When this was asked if the board has done this, we were told, no. The board has never seen this, the board never approved this, and that is an overreach because that is not something that CDD actually has the authority to do. So that's what I have on this topic. So we do have more. We have road safety, we have fire safety, and grading, and we'd appreciate additional time on that.
I'm sure there'll be questions, and we can get to those, I think.
Okay, please ask questions.
I'm pretty sure they will.
We provided the presentations so that you can go to any section and ask any follow-on questions.
All right.
Thank you.
Okay. Do we have questions at this point, or are we, what's that?
I can wait, but I do.
Okay.
But I can also wait.
Do you guys want to ask questions now, or are we allowing the other party to? Lloyd?
With res-
That's at the discretion, thank you, Mr. Chair. That's at the discretion of your board. Typically, what follows is after the appellant provides testimony, then the members of the public, including the applicant, of course, can provide their testimony. They're sworn in.
Go ahead, Brad. Ask your question.
Yeah, my questions at this point are just going to be related to the road. I realize it does cross federal land, but it's a public county road. There are hundreds and hundreds of miles of state highways and county roads throughout the state of California that cross federal land. And those roads, particularly the state highways that are crossing, say, large swath of national forest in California, have hundreds, if not thousands, of commercial vehicles traveling those. So, and I'm not aware of all of those commercial vehicles happen to get permission to cross any of these roads all over California. So that's my question regarding that. I don't see this road as any different than a state highway going over a national forest.
Thank you, Vice Chair. That may be the case as far as practicality, but it is clear that in this specific instance, the BLM has explicitly denied authorization to Poverty Flats. And the list that I've provided you are ones where the BLM has they haven't not answered. They didn't respond with silence. They responded with explicit denial of that permission to cross their land for that purpose.
Supervisor Sabatier?
So I would like to hear from County Council on how to respond, the commentary and the posturing at this moment in time. Like, if I was on a phone call, I'd say, at this moment, we can't have a continued conversation because it sounds to me like you're suing us because you just called us criminals or aiding and abetting, and I'm just not sure how to respond and how to carry on in open session rather than this. I need County Council to advise this board on how to move forward because I feel like a threat has been made that I don't think I should be opening my mouth right now.
Lloyd?
Thank you, Mr. Chair. So what's before your board today is an appeal hearing that's coming out of the Planning Commission's decision. It is a de novo review, so your board is entitled to, certainly is within your board's discretion to take in any and all evidence and give it its proper weight based on relevance, right? So the references that Supervisor Sabatier raised, I mean, that is technically speaking as part of the presentation evidence or arguments that's being brought forth to your board for purposes of what this item is calling for, which is an appeal hearing before your board for a decision, or technically, be more specific, an intended decision or a decision in concept. Your board can certainly take whatever's being said, whatever's being presented to you, its proper weight. That is not to say that when it comes to under the Brown Act, any certain statements being made that may be a candidate for a potential litigation caption or item to be taken by your board in closed session, that's certainly that's certainly a possibility, but that is separate from what's being presented to your board today in terms of what evidence to take in based on relevance, right, and its proper weight, for purposes of coming to a decision on this appeal.
Not hearing any other questions from the board. Did you have something else?
Yeah, I don't know that necessarily helped me out. I, if I may, would advise the board that if there's other issues or concerns or topics to discuss from this appeal, that should be open. But I feel like this latest discussion, any comments made will and can be used against us based on the language that I just heard being used. So
Right. So I'm not
Yeah.
seeing any other questions from the board, but what, you want to finish and
Well,
add?
on that topic, I fully respect what Sabatier is saying. I mean, this hurts everybody, so you'll have to make your decision how you want me to proceed.
Okay.
Yeah.
Well, we are at that point. We're actually at like 25 minutes now, and so we still have to allow the other group to speak.
If I could just present quickly the grading portion of this, because that's really where this all stems from, the whole, and I will go very fast through the grading. It's not, honestly, it's 5 minutes. It's slide after slide just to show the history, the sequence of events that happened on this property.
Just do the slides and let's finish up.
Okay, so Johanna, we'll need to reload the next one because it starts with the grading.
When did the grading take place?
The grading actually took place in 2021,
Okay.
prior to their grading permits. Number 2.
There it is.
Okay, great. Thank you so much. I appreciate this. Okay, so the handling of the project by the applicant and the county was flawed from the beginning. The excessive grading without the required permits in place set the stage for this project to be doomed, and the county attempting to cover it up only made it worse. So we're gonna just flip through the timeline of how, okay, so High Valley has significance. We all know that. This is a picture of the property in 2017, or 2018, July 2nd, 2018. This was before the Mendocino Complex fire. This is what their land looked like. This is a picture of it after September, a year after the fire, where we see no grading, no dozing, nothing as was suggested by the applicant. The next slide is an excerpt of an email in 2021 of Mr. Barthel asking about permits. This picture is 4 days after he asked about the permits without having one. This is the grading that was done, and we can see that new roads have been made, trees have been removed in the lower left-hand corner, and grading through stream beds with no stream bed alteration agreement in place, and culverts being put in. So this is April of 2021. So the ministerial grading permit they received in April of 2022, which was a year after that last photo, that permit authorized minimal soil disturbance and clearing of existing fire breaks, existing property access, including road widening to comply to 4290, and all of this widening is to be conducted on areas with less than 20% slopes. So here's where it talks about flat ridge slopes, which they are not. That's a tier 2 enrollment where you can only have slopes less than 50%. So otherwise an EIR is required, and the parcel average is 39.5% slopes. These are slope overlays. The old parcel viewer shows that green is greater than 30% and requires more risk analysis and assessment. The new parcel viewer shows where yellow is greater than 30%, red is greater than 50% and not allowed, and you will see some of the red in their cultivation fields. These are also soil map surveys showing high to severe erosion risk. Okay, so 6 months after they received their permit, they had continued grading. There's much more action happening on this land, excessive grading, new roads beyond the permit limits. And then the tribal consultation happened, or didn't actually. I did have a conversation by email with Mr. Moda on October 17, 2025, that said he did have an initial site visit, but did not receive any further contact from the county or the applicant. So no consultation has occurred for anything that was previously graded. This is, the left image is an image from one of their reports, from a cultural report, showing the trenching that was done by December 2023. This property never had a well, and a well was put in 2022. These lines were trenched for going to the cultivation site. This is all infrastructure, which falls outside of the CEQA purview.
If you could start wrapping up, please.
So this is the further field expansion in 2024. We submitted code enforcement complaints, which returned nothing. There was no problem. So that was all okay. The county knew that the complex grading permit needed to be issued. This is important. This is where the project calls for a complex grading permit. It was issued, but the applicants balked at it and said, we don't want to pay for it until after we get the permit. So the county then had added it to the ISMND in January and uploaded that, it circulated that ISMND for public comment and agency review in January of 2024. 2025. Then they uploaded that document to CEQA. The applicant complained about the complex grading permit, so the county voided it and then changed the document, the ISMND, in April, and submitted that changed document to the Planning Commission in Planning Commission in a redlined format. So the Planning Commission never saw the ISMND that referenced the complex grading permit GR 25-01, and they passed the project, and then the CDD cleaned up that ISMND of all the red lines and uploaded that to CEQA in May 27, 2025. So you have a changing document that references a grading permit that they need, it's removed, and then that document was then passed and sent to CEQA. So that's destabilized the actual project itself. And all of this grading that happened before their permit destroyed the baseline of the project, which undermined any sort of tribal mitigations or biomitigations that were in the project, and rendered this whole project infeasible and damaged, so unable to process.
Thank you, Maria.
So sorry that, I mean, it's
No.
I could be,
It-
but
it's-
this is
yeah.
this is not, this is why this took so much time and effort. There were a lot of things to.
Right, and you ended up basically getting the half hour you wanted, so I'm
Thank
just
you.
letting you know.
I do appreciate it.
It's
because
it's,
there was a lot of damage
we
done.
still have a long ways to go too. you know,
Okay, so I don't know, I'll get a closing option.
Well,
for my closing?
as of right now, we haven't even heard the other, yes.
All right.
Supervisor Sabatier?
I'm wondering if CDD has any responses to some of the comments made about grading and things like that. And the rescinded or not rescinded.
Yeah, we're happy to go over the
GR25.
timeline to address the statement about covering up past grading violations, as well as no tribal consultation on previous, or grading previous to the application. I'll turn that over to Senior Planner.
Thank you. Under our current grading ordinance, there are a set of exceptions from the needing a grading permit. And at the time that the permit was applied for, the staff member conducting that review determined that it could be exempt under that clause in our grading ordinance. So it therefore didn't require analysis under CEQA per that grading ordinance. Now moving forward to the grading permit that the appellants have mentioned, GR 2501. That number came from a time right when we were switching over to OpenGov. So the applicants applied for a grading permit as a part of the process of getting through the initial study and the use permit. We have allowed applicants, not just this applicants, all of our applicants to apply for the permit so that we may analyze it under CEQA. So that we don't have to do additional CEQA. If the use permit is approved, then when they come back to get the grading permit issued, we don't have to do additional CEQA. So in an effort to, analyze the full project and not piecemeal, we analyze everything at once, which requires them to submit that application. We did not revoke or whatever the word that was used, we didn't rescind that application. It was just consolidated into the PL number. I know that's getting a little bit technical, but it came from switching from Acela to OpenGov. So just to be really clear, the complex grading permit for the cultivation will be issued if the use permit gets issued as well. So there will still be a complex grading permit. We just intake preliminary information and plans, and then we allow applicants on the back end, because it's a follow-up submittal, if you will, sort of like an air quality permit is. It's a follow-up action. So that, I hope, clarifies that and where the numbering happened with that permit. And then, did you want to add to that? I was just going to say, I also have clarified, I just want to clarify for the record that tribal consultation did happen with ELIM for the use permit project. I have the minutes and the agenda, which of course I can't share because it's confidential, but we did go through our records and make sure that took place. So just so there's no confusion from the activities that are covered under the use permit.
And they have to remain confidential because some of the sites, they don't want people to know where the sites are when it goes to the cultural,
The point of
historical.
AB 52 consultation is for the tribe to come to our office so that we can talk about, or we can learn their information, which remains confidential. Additionally, we do not hold AB 52 consultations on grading activity in the past. We have no mechanism for that. Nor when grading permits are determined to be exempt from CEQA for a variety of categorical or statutorial reasons, do we move on to an AB 52 consultation, which is triggered when we're at a neg deck or a mitigated neg deck level.
And consultation occurred on January 8th. I just wanted to clarify that. Just closed it.
You say 23.
2024 is when actual consultation took place at 11 a.m. here in our office.
All right. Is there anything else you wanted to address,
At this time, we're happy to answer any other questions the board might have.
Supervisor Sabatier?
So I'll just bring up something because I'm hoping to get some clarification, most likely from the applicant. I know they brought their hydrology expert with them, or at least the individual who put the hydrology report together. I believe it's 5-point-something acres, 16 acres. I knew it was less than 5.25.
5.69 acres.
5.69 acres. We're looking at 3.65 million gallons of water with a single well that only does 40 gallons a minute. And so when I calculated all of that's quite a long, like if you calculate it by continuous use, that's like 68 days straight of pumping water. So I'd like an explanation. I know there was a fair argument that was thrown out, and so I think it's something we can't ignore since it was provided by the appellant. And it's one of the things that popped to me when, okay, if you were doing an acre, I would probably say 40 gallons a minute will probably cover that. But 5 acres at 40 gallons a minute, I have concerns and like to get a better understanding as to what the impact will be to that whole area, just a better understanding.
We are happy to defer that to the applicant's team for response.
So the applicant, if you would like to come up and if you wanted to have some time to speak as well. Yeah, should we, do they need to do a PowerPoint or anything like that? Okay, so we're gonna need a couple minutes to switch out then. Yeah. Okay. Yeah, they're gonna need, do we need a couple minutes? We'll take 2 minutes and we'll take care of this exchange. All right. Yes, you do. You need the microphone.
Great. Thank you. I think I will turn this over now to the applicant's team for their introductions and presentation.
I'm Angie Dodd, agent for the applicant with North Point Consulting Group. I will be giving the presentation, and with me is Praj Wright, licensed civil engineer experienced in transportation engineering, and then James Anderson, attorney at law with expertise in CEQA and land use.
Right, and as I stated to the other group, let's try to move through this pretty quick, but
I
we'll
tend to talk really fast, so I will try to slow down, and I've made a shortened version, so hopefully this will go pretty quickly. My timing was less than 30 minutes. We'll see if I can keep that up. So I wanted to thank you for letting us present today, and I wanted to thank the planning department for all their assistance on this project. This is one of the bridges on Poverty Flats that was discussed. So quickly, what the Poverty Flats application is, it was applied for. Oh, sorry, I've got to do both because I can't read up there. I have an eye challenge. There we go. Sorry. So it's 5.69 acres of outdoor cultivation area. That's what we're saying is canopy, but what will actually fit in that, if you consider aisle space and everything else, is probably going to be about 70% of that over the almost 200 acres of property. There's 4 ancillary greenhouses for immature plants or nursery for on-site only. Solar power with a backup generator, 79,000 gallons of irrigation water storage, 15,000 gallons of dedicated fire storage with a fire riser, 2 regular employees and up to 7 seasonal, no tree removal. There's a preliminary grading plan that was included with the application that was part of the confusion today. That is the grading that was evaluated in the CEQA document as part of that, was it GR 25 something something? There's a minimum setback of 100 feet from streams, no off-site residences within 1 mile of the project, and there is an executed monitoring agreement with the tribe. So what is this project in terms of existing zoning? So the zone is rural land. The project itself is consistent with uses that are already permitted, although cannabis cultivation itself, an ag activity, requires a major use permit. What uses are permitted on this land without a permit are agricultural uses. No limit to the amount of that, although cannabis has a limit of 1 acre of outdoor for every 20 acres of parcel size. Greenhouses less than 10,000 square feet. The applicant is proposing 8,700. Processing building less than 2,000. The applicant is proposing 2,400 square feet, so that would be subject to a minor use permit if it wasn't cannabis activities. And then allowed uses without a permit are agriculture and residential accessory uses and accessory structures similar to residential size on-site wastewater treatment systems and stuff like that. The Poverty Flats applicants, they will speak during public comment, but the property is family owned and it's been owned and maintained as a ranch since 1978. Kurt Barthel is a retired deputy labor commissioner, formerly worked for the Lake County Sheriff's Department and Welfare Department. Robert Barthel is a retired city employee of Lakeport. Jeanette Derry is a retired school teacher. This family is dedicated to the responsible stewardship of this land, and over the years, they've done a lot of cleanup on this and maintenance of this property. So the project appeal, it's being brought forward by an opposition collective focused on extinguishing commercial cannabis projects in Lake County. As you are all aware, they did a huge document dump of thousands of pages the days before the hearing. And in reviewing those documents, which we have spent the time to do, there's heavy use of comments submitted in opposition to other projects. Many don't relate to this project. Comments show signs of heavy AI use, including flawed structure and incorrect case citations, suggesting a focus on word count rather than substance. Comments, while intended to relate to the project, are clearly part of a larger campaign, and comments amount to a great deal of hand-waving, seemingly intended to distract the board from relatively simple underlying CEQA concepts that favor the Planning Commission's decision to approve the project. So I wanted to point out the expert contributors that contributed to the responses and the documents in the record. I myself am a licensed civil engineer with a PhD in water resources engineering. I have over 30 years experience in water resources, hydrology, groundwater, civil engineering projects, and then I even did a stint as a traffic safety engineer at Caltrans. Living in a small county, you kind of have to do a little bit of everything. Praj White is a licensed civil engineer working almost 30 years in civil engineering, and transportation analysis. Geo Graining has a PhD, conducted the biological and botanical resource assessments, and he has a PhD in those sciences. James Anderson and Brad Johnson also assisted with addressing land use components and CEQA components. So what is the CEQA standard? The appellants invoke CEQA in their comments, but fail to clearly articulate the correct legal standards that must guide the board's decision. In adopting an ISMND, which is an initial study mitigated negative declaration, I'm going to say MND or initial study, that's what I mean as an ISMND. CEQA states that a lead agency must prepare a negative declaration or mitigated negative declaration if the initial study shows that there is no substantial evidence in the light of the whole record before the agency that the project may have a significant effect on the environment, or the initial study identifies potentially significant effects, but the proposed mitigated negative declaration would avoid or mitigate these effects to a point where clearly no significant effect would occur, which was shown in this case. The fair argument standard is thrown out quite a bit. What is the fair argument standard? When reviewing a challenge to a lead agency's adoption of an MND, a court will evaluate whether any substantial evidence in the administrative record supports a fair argument that the project may have a significant effect on the environment. Substantial evidence are facts, reasonable assumptions predicated on facts, or expert opinions supported by facts. What is not substantial evidence? Argument, speculation, unsubstantiated opinion or narrative, inaccurate, uncredible evidence, personal non-expert observations on technical matters, or non-expert non-expert testimony on technical subjects. And then we talk about preparing an EIR, which was brought up quite a few times for controversial projects. Can an EIR be required in this case? No. Public controversy regarding an alleged environmental impact cannot in itself require the preparation of an EIR, nor can the mere possibility of an adverse impact on a few people as opposed to the environment. When the Planning Commission adopted the ISMND, they correctly determined that there is no substantial evidence in the record that supports a fair argument that the project may have a significant effect on the environment. As shown to the responses to the appellant's claims, nothing constitutes substantial evidence supporting a fair argument standard. On this basis, and on the basis of all the evidence in the record, the board should deny the appeal and affirm the Planning Commission's approval. Just going back to what Poverty Flats is. Simple outdoor cultivation project, 5.69 acres over a 200-acre ranch, designed according to county ordinances and sited to avoid resources. It's consistent with allowed agricultural uses on the property. It's consistent with similar operations approved throughout the county, the size of which does not warrant thousands of pages of supposed environmental impacts. And the data shows that the project will not have a significant effect on the environment. The appellant's claims were summarized in 12 chapters. I'm going to go chapter by chapter. This is the list of items that they've already covered in their presentation. But after review of all the comments, there's no demonstration of any defect in the Planning Commission's decisions. The appellants have failed multiple times to point to any substantial evidence in the record supporting a fair argument that the project may result in significant impacts to the environment. So the first chapter regards access and indemnification. And in looking and they claim unlawful federal trespass. The project is accessed via county-maintained road. We're all aware of that. It's county right-of-way, and county right-of-way through BLM land does not require authorization from BLM. I went to the BLM's website. I looked at their applications. What BLM says on their website is authorization is not required for casual activities such as driving over existing roads. The project is not located on federal land, so it does not trespass. Indemnification agreements are a standard practice statewide. We do permits in multiple counties in California, and we see them as standard practice. The operator is assuming all risk, and the applicants mitigate their risk by following all state and local laws. A couple things I wanted to point out is precedents. Humboldt County issues permits that access across federal land all the time. They have comment letters from the National Forest Service that recommend denial of the project because cannabis is federal legal. They do similar action as Lake County. They identify that this comment came in and they still approve projects, even though access is over forest land, and that's even in the case where it's not a county right-of-way. See it in Trinity County, and I even reached out to the planner in Mendocino County regarding the example that the appellants provided. She used to work for Lake County, and she said, Lake County isn't Mendocino County, we have different ordinances. So it's apples to oranges comparison. Ooh, okay, so the next chapter, road safety, mostly refers to High Valley Road. There's the argument that there was an improper use of vehicle miles traveled for safety evaluation, that cumulative impacts weren't addressed, and that High Valley Road has design deficiencies. The project has a minimal traffic volume. There's 2 permanent employees and 7 seasonal employees. The project is consistent with allowed uses, as we've already discussed, which have already been considered in the county zoning code and general plan, so that traffic was already accounted for in those documents. The project does not propose any changes to road alignment or other features and does not result in the introduction of any obstacles that might hinder emergency access or traffic safety along High Valley Road. No roadway improvements are warranted based on the low traffic volumes reported by Caltrans for High Valley Road, which is about 45 to 55 vehicles per hour. A roadway capacity, and that's peak hour. A roadway capacity analysis was conducted by Mr. White, and it's in the document that we uploaded, the response to the appellant's comments. This analysis shows that High Valley Road is operating well below roadway capacity. Capacity is between 825 and 975 vehicles per hour before, that's level of service E in roadway lingo, meaning that's the capacity where you have a traffic jam. There was also an evaluation of collision history. It was done improperly per traffic safety standards. You only do collision history based on collisions themselves. There were 9 collisions over the most recent 5-year period. I evaluated those 9 collisions. Most were due to driver error or DUI, and then one of those was a pedestrian error. And when looking at the trends, which is in the document I provided you, there are no trends linked to the proposed project traffic. So the appellants provide no substantial evidence of a fair argument that the project would exacerbate hazards on High Valley Road because none of the claims indicate that the project has a component that would increase hazards due to project design features or through the addition of new incompatible uses. Appellants fail to show how the small amount of increased traffic is incompatible with current uses and would add a hazard to High Valley Road. So there's discussion on fire safety regarding 4290 compliance not applied to High Valley Road. The road is unsafe for evacuation and the ridgeline must remain undeveloped for fire safety. For this project's review, 4290 applies to the on-site access only and is triggered by the new 2,400 square foot structure, which in Lake County is considered a commercial structure. Mitigation measure WDF1 ensures compliance with that standard. Article 27, access standards for cannabis projects only applies to on-site driveways and not county roads. The project was routed to CAL FIRE for review. No concerns were raised regarding High Valley Road. CAL FIRE comments regarding the project were addressed by the applicants by adding fire storage, meeting on-site road standards, and including defensible space around structures. High Valley Road was successfully used by firefighters during the recent fires. The applicants even helped CAL FIRE and allowed them to use their property. The roadway capacity showed High Valley Road is operating well below capacity. The project traffic is negligible. And again, the project area is only 3% of the entire parcel area, and it's a very small component of that ridgeline. The property owners routinely maintain the property by removing fuel, maintaining fire breaks, and providing access to water on site. As part of the building permit process, CAL FIRE and county inspectors will verify compliance with Section 4290 prior to issuance of a building permit. The appellants failed to show how the small amount of increased traffic or project design features would have any contribution to evacuation or the ability to fight fires.
So you're at your 15 minutes, but you continue.
Okay. Next is what is reference to the ministerial grading, GR22, the complex grading permit and piecemealing. I think this got handled by planning staff. That 22-12 was issued prior to the use permit. When I looked at Google imagery as the appellant was presenting, the image was actually, there's an image in June 6, 2021 that shows no grading, and then the next image is 10/2022, which shows the work. So I'm not sure where they're getting their dates, but according to the applicant, according to Google Earth, the grading activities associated with 22-12 was conducted appropriately and when it was supposed to be conducted. The water line repairs were part of existing water lines, and the work was done within the existing roadway. The issuance of GR 2501 was discussed. That's just a numbering thing. It wasn't, the evaluation and preliminary grading were included in the CEQA document. And a grading permit will be obtained after, once the project has seen approval and an engineered final grading plan has been prepared. There was no illegal grading or piecemealing conducted as part of the applicant's activities. Procedural brief, responses. So there were many claims regarding CEQA. I'm going to let James handle this later, but just quickly, over and over, it appears that the applicant's claims are based on information that fails to demonstrate a valid CEQA deficiency. Lake County staff held this applicant and the application documents to a very high standard. Baseline conditions were developed based on reports and findings of technical experts. Recirculation of the ISM&D is not required if revisions include only minor technical changes, clarifications, amplifications, and insignificant modifications. AB 52 consultation was conducted. I actually reached out to Clifford Moda because the applicants reached out, and I wanted to clarify what went on with the grading and make sure that the mitigation measure was appropriate. And he indicated that he really did want to have a monitoring agreement in place for potential activities on site due to resources. So I encouraged the applicant to go ahead and move forward with that agreement with the tribe, and that was done. There's the claim that a mitigation and monitoring reporting program wasn't done. That isn't required. Conditions of approval is an option for that, which was done. County staff did a detailed CEQA analysis, accurately representing baseline conditions and level of analysis required for a project of this type and size, and they did multiple levels of review, both local and state, and public comment before being adopted by the Planning Commission. This is just an example of all the state, that whole list of state agencies the CEQA document is routed to when it's uploaded to the state clearinghouse. Biological resources, a detailed assessment was done, both biological and botanical, by GeoGroning. Methods followed standard practices and protocols. The study area was determined based on the location of the project elements and proposed areas of disturbance. The project is located on ridges and set back at least 100 feet from all on-site Class 3 drainages and much farther from all other water courses, including potential wetlands. The biological resource assessment did not identify any water resources within the proposed project areas. And concluded that the project areas have been designed with 100-foot setbacks from channels and are situated on flat ridge tops. Because of these avoidance measures, no direct impacts to water resources will occur. A site visit was conducted recently with CDFW in October, just in preparation of the lake and streambed alteration agreement. No issues associated with the proposed project or the site were identified during that site visit. Multiple mitigation measures are incorporated for erosion control, for water resources, water board and grading permit compliance, restricted grading work window, and nesting bird surveys prior to construction, along with compliance of those rules incorporated by law. No substantial evidence of significant impacts have been demonstrated, and mitigation reduces impacts to less than significant. I'm just going to skip this slide. It's just more discussion of CEQA and failed to demonstrate the fair argument standard. And then hydrology and water supply. There were accusations made without any technical evidence regarding this. The appellants utilized comments on many different projects out of context and without providing evidence or factual support. The appellant cites on other projects, including the Sowers appeals and Sauer's appeal and misuses the information provided by me on that appeal. That was an 80-acre cannabis project with thousands of square feet of processing. That is a whole different situation. The appellants make faulty conclusions based on a misunderstanding of the information regarding the local geology and groundwater formations. As a licensed professional, I prepared the hydrology report for Poverty Flats. The well associated with Poverty Flats is not in the same aquifer system as Sauers or Monte Cristo. Thus, using information from these projects is misleading. Oops. I prepared a detailed report, including estimates of supply, demand, cumulative analysis, impacts, etc. The surrounding wells within a half a mile were included. The closest well is over 2,500 feet away, and I included that well in the analysis. That's an adjacent cannabis cultivation site. I interviewed that applicant on their well use and how prolific their well is to help in the conclusions in the report that I developed. The radius of influence of the project well is about 350 feet. The report included recommendations for monitoring and reporting measures, along with suggested drought contingency measures. I include detailed monitoring and measures and recommendations in almost every single one of my hydrology reports because I think that's important for agricultural activities and water use because it's dependent on how much water you're using. And my analysis included the driest year on record and demonstrated sufficient recharge for the cumulative impact area during the driest year and for a very conservative high estimate of demand, assuming the whole 5.69 acres of cultivation area would be cultivated, which is a little high. It's probably 30% high. And then I used a 180-day cultivation season. When I'm seeing in Lake County, they're more like outdoor cultivation is more like 120 or 150. And then again, the appellants failed to identify any site-specific factual technical support to demonstrate there is an impact associated with Poverty Flats. And Bruno, to address your comment regarding use, in my report, you need to refer to the actual maximum daily demand and the amount of water storage. So the amount of water storage, if it's what the less conservative or the high conservative numbers, I think is about 3 days. If you use less, it's 4 to 5. So it's a slow fill up and use. So you're not overtaxing your well, and it's over a long period of time. It's not an annual thing. You have to look at peak daily amounts for water use and watering. And then cultural resources, I'm pretty sure this was addressed, so I'm going to skip through it. If you have any additional questions on that, just let me know. We discussed the monitoring and the grading. I think that was addressed. And then slopes and survey. The site plans did include a boundary survey conducted by a licensed land surveyor. The map topography on the plans is not based on county slope map data. That's a different calculation for type of map data. It's based on DEM. It's not appropriate for site-specific topography. The map topography on the plans is based on LiDAR data. It's 6-inch resolution and developed under a licensed civil engineer. And then the BLM letter was included in the agency comment at the Planning Commission. It recommended a professional land survey, and it only recommended, they all have to recommend denial of the project because it's federally illegal. I see that on the letters from the Forest Service as well, but the projects are still approved.
If you could start wrapping up.
Yeah, I'm almost done. All right. Oh, and the water board tier level enrollment, that's determined by the water board. That's not determined by the county. It's not in the county's jurisdiction. And we worked with the water board very closely to do the appropriate tier. Keep going. Just solar. It's an outdoor cultivation project, minimal power use. They propose to use solar power, a backup generator when needed, likely a small generator that won't require an air quality permit. And this comments were routed to both CAL FIRE and air quality regarding these. On-site septic, it's a standard on-site wastewater treatment system. It's consistent with allowed uses on the property, and it was fully assessed in the ISM&D. If for some reason the building doesn't get built, there won't be a new on-site wastewater treatment system because it won't be required. And then the project well, there's claims that it was misclassified as an industrial well and that there was no proof of well compliance or regulations. The well was drilled, constructed, and permitted as an irrigation well by a licensed well driller. It has a valid permit issued by Environmental Health in May of 2022, and the project doesn't propose industrial uses, which is washing, extraction, etc. And then conclusion, this just restates what I said at the beginning. The project is consistent with allowed uses on the property. And that after review of all documents and as shown in the responses to the appellant's claims, nothing constitutes substantial evidence supporting a fair argument standard. On this basis, the board should deny the appeal and affirm the Planning Commission's approval. Thank you.
Supervisor Owen?
Your 6 gallons per plant per day estimates, is that an average? Was it, what?
Is it per day?
I don't use that estimate. I use it as one. I use it as one. I base my estimates on square foot. And I also base it on flowering versus the different scales of a plant. I'm drawing a blank on the other one. And it's the 2 stages that go. So I don't, vegetative stages. So I use it by square foot of plant, not by per plant. And that 6 gallons per plant is for a very large plant.
Okay, yeah, I was just Googling it to find out what, and it has like about a double that figure for a large plant. It has on here about, I think it was 10 to 15 gallons.
Yeah, I base it on square foot from certified sources, and it's very common numbers used in multiple counties.
Okay, I was just.
And I do a
worried
big spreadsheet analysis based on size of plant, based on flowering and vegetative states. So it's more complicated than just the 6 gallons per plant.
Sure, because from the time it starts to the time it matures, there's a huge difference. That's what I was asking. Though your information is bringing forward, is that an average on the full length of the plant, or is that at the higher end of the
So when I do the
needs?
Yeah, I'm not looking at the report in front of me right now, but I usually calculate the average, and the average over the year tends to be a little bit higher than that 6 gallons.
The standard is about 500,000 gallons per acre that we see throughout more arid regions. And that accounts to something like 12 to 15 gallons per square foot per year. And
Which
that
is
consistent with what you see for irrigation, where you see about an acre foot per acre.
Right, so it's about double the because what you're more worried about isn't the early on, it's when water gets more sparse. And that's what we're worried about, whether you actually have enough water to maintain it in the higher, as the plants get larger, not an average, but at the peak.
Absolutely.
And that was my question.
Supervisor Sabatier?
Could I finish? Sorry, Supervisor. Just to respond to that, that's why I do a daily and max daily analysis to identify when the maximum irrigation is occurring, and I do the analysis based on that maximum. And then, like any agricultural activity, you need to curtail your agriculture when you don't have water. So, and that is a definite agricultural activity.
And one of the issues we've had is water, obviously, throughout the county.
All right, Supervisor Sabatier?
Yeah, and I just wanted to say that on page 2 of the hydrology report, it does have the month-to-month outputs of how much water is to be utilized. So you do see the increase. And I would suggest that looking at Google, I have seen giant trees, and I have also seen what our legal cannabis does. Nobody's trying to make it on the cover of High Times anymore. They're trying to make some quality cannabis in order to make it in the market. And I have never seen anything taller than maybe 4 or 5 feet on a typical farm. So, and again, it would take up so much more room that you'd have less plants. And so it might still be the same water amounts, but I know that we've seen a lot of these with the amount of water being utilized. Just a brief question on the hydrology report. There's no static level specific. And during the months of, I'll say August, because that's really where the number goes up, between August and September, that's when you're seeing a very high level of above 700,000 gallons per day. I'm guessing that's a per day. It's under the month, but no.
I have a max daily in there. I'd have to.
It would be for the month. It would be for the month.
Let him finish his statement before you respond,
Sorry.
please.
that at that point in time, yes, you might have 3 days worth of, and again, I'm guessing that's an average of water tanks for water, which might be used a little bit faster during those months where there's a heavy use of water, which means you'll be drafting water a whole lot without knowing what the static level is of the well. And we've only done, if I remember correctly, a 2-hour well test to see how the well replenishes. Do you have information on how it replenishes if it's running for 12 hours a day at that really high point that you'll be utilizing?
And what time of year?
And that would be in September and October.
Yeah, so the maximum daily is during the flowering period, and that's 27,000 gallons per day, and that's a high estimate. It's conservative high. So that was what I was trying to get at before, not 700,000. And I interviewed the neighboring well owner who has a cannabis cultivation project similar in size, and his use is who these applicants are going to be working with. Water use is much less than way less than what I've implemented in here. And he indicated that as well as in this, I've identified his well in the same water-bearing formation, and it was my interviews with him over the 5 years that he's operated that he's had no problem with water from his well.
So is that like it was a witness well? Mm-hmm. Did you have something else?
And so again, when I do the 27,000 and I try to go down to how many hours in the day, that's 11 hours a day that you would be using for 27,000 gallons per day. It concerns me because it's not just, we're looking at the whole. We're not just looking at, are you going to impact a brass field? Are you going to impact other neighboring grows? It's also the environment, because the environment requires water as well. And so the water table feeds all. And I don't feel like there's, or at least I don't feel I'm understanding that this will have less than significant impact, at least during those 2 months, versus those earlier times where it's a whole lot less. It's maybe 3 or 4 hours a day as far as the watering that starts over in April and May and June. And so just kind of curious if you keep talking about that, just because I need to better understand the water situation.
So I'm not really understanding what the question is. So the neighbors have demonstrated using similar amounts of water that there's been immediate recovery. You pump it to storage, you allow it to recover. There's been sufficient water throughout the entire season for similar amounts of water. These are really deep wells. I'd have to skim through the document to understand the exact.
And I don't mean to interrupt, but earlier you mentioned to separate between the neighbors and yourself. It's not like Sours, it's not like Monte Cristo. They're in a different basin. So how can you say the neighbors are refilling? I'm looking for, can you refill?
It's in the same water bearing. There are 2 wells. It's in a very sparse well area. The only nearby well is the adjacent cannabis cultivation site. Based on the well geologic log, they're in the same water bearing formation. So they're drawing from the same. I did the analysis cumulatively with the 2 wells, and I reached out to that adjacent property owner to make sure that I was doing that analysis properly and accounting for appropriate water use and recharge of that well, which is observed by that property owner in their activities.
I think maybe clarifying that the 2 wells are up on the ridge and they're not down in the valley, and she's identifying that the ridge aquifer is a different water bearing formation than that down in the valley.
So just, I know cumulative impact is something that we failed to do at the beginning. I think we've added and we've made it a little bit more, I don't know what the right term is, but we're paying better attention to the cumulative impact. I know that we're paying attention to all the stuff that we've approved to show, and also the ones that are on the docket for potential approval. That way we have a better understanding of what we're saying yes and no to. But is the cumulative impact only human activity, or does it entail also the needs of the natural environment around you as well? Because if the water table goes down and we know it's a high fire hazard area up there, doesn't that potentially create for drier environments for that area, especially when you're drawing a whole lot of water, is when we're seeing some of our most hazardous times for fires?
But we're drawing water from like 200 to 300 feet deep.
It said 400.
I'd have to scroll down to the well report to figure that out, but just giving me time to
I
get the
think it
data.
said 400.
400, so it's a pretty deep well. So in terms of impacting vegetation on site and around, that aquifer is well below surface.
And it's isolated.
And it's isolated to the ridge, yeah.
Supervisor Owen?
Okay, let me see if I can articulate this where you can understand my thought. What time of year or when was your well test done? Do you know when?
The well was drilled in August 2022 during a dry year.
Okay, so it was, okay, that's what I was looking for. And then I believe, if I understand Supervisor Sabatier's question, is you may not be on the same aquifer or on the same, as the water goes through the ground as your neighbor. Therefore, have you done the studies on your well as far as the recharge on your well? Because
You mean a 4-hour well test?
Yes, more than a 4-hour well test, like what the recharge is.
So typically in Lake County, it's a 4-hour well test.
But you haven't done yours.
Not on this project, no.
That's what I'm asking.
But I wanted to also point out that there are things I add to my hydrology reports, because even if you conduct a 4-hour test, even if you conduct a water system 10-day test, we all know that groundwater changes. And it's possible that it changes, and it's underground. You see my caveat in my reports. There are unknowns that exist there. And this is an agricultural project, and agricultural projects rely on reliable water. So I add mitigation measures into my analysis for detailed monitoring and reporting. These have been incorporated as mitigation measures. For me to make a conclusion of no significant impact, these wells need to be monitored from a operational basis, which is what the county requires, a monitoring, and on a seasonal basis. What's the water level in the well at the end of the season? What's the water level in the well at the start of your next season? Is it truly recharging? If not, what's your plan? Provide that plan to identify that to the county, provide that plan to the county. That's part of their mitigation measures for this project, is they have to monitor and report for those activities. That's how I account for that unknown in a groundwater aquifer and these isolated ridge aquifers. That's really, really important for water supply.
An examples of those mitigations would be more efficient irrigation systems, less plants, less square footage. That would be the adjustments that would have to be reported to stay in compliance with the mitigation measure.
Well, I'm glad that you did the testing in August, because I know we've had others come before us that had done them on a rainy March, on a heavy rain year. And they're trying to bring those forward as this is what our well produces. Thank you.
You're welcome.
From the board. Go ahead, Supervisor Sabatier.
Yeah, just my last thing, it's just something that unfortunately keeps coming up, and I guess I like to be a little consistent in my arguments. It is the scenic corridor. We keep using the 500-foot setback. That 500-foot setback is not a written setback in our zoning ordinance. It is a manufactured internal policy that has been done. I would love to see the scenic corridor come back with greater detail so that we can make that happen, because it's hard for me to accept doing a setback on something that right now the law as written it speaks to the whole property. It does not speak to a specific area within the property. It does not describe how to dissect the property of what's approved, what's not approved for scenic corridor. And this is the third such situation coming to us as a Board of Supervisors with an appeal that has a scenic corridor setback that is being utilized that is just not in our statute as far as the setback goes. So I'd love to see if, again, there's new information to state otherwise, but from what I understand in our last conversations, there is just nothing that says there is a setback. It is a parcel scenic corridor, not a 500 feet from the road setback.
Thank you. Your request or your interest in developing a better thought out policy has been noted and is actually included in draft Lake County 2050 documents to make sure we don't set it aside indefinitely. Through review of past correspondence with former directors, it has looked like an internal policy with a preference to avoid involving an entire parcel for the purposes of not prohibiting development for, say, a 500 or a 600 acre parcel because part of it crosses into a scenic corridor. So that is going to take considerable thought, as well as figuring out what other jurisdictions are doing and evaluating in order to present something to the board that will then become formal policy. But we're not ready to do that yet.
All right. With that, Lloyd, just wanted to see if public input, do I do that or only the sworn in?
Your
Folks who
board may, thank you, Mr. Chair. So your board may wish to see if there is other testimony to this effect. And your board also has the discretion to allow for rebuttal testimony. So it's up to your board as far as the order of this, for purposes of anyone who hasn't spoken yet.
That's where I was going.
Outside of the main sides of this appeal hearing, and then allow for rebuttal. That is an option for your board.
I'll bring anyone up that hasn't spoken yet. If you have a comment and you'd like to speak on this project, please come on up. And let's try to keep it very brief. We'll go with 2 minutes at best.
At best.
Is this public comment part?
2. Yeah. Yes. Yes.
Okay. Good afternoon, Chair and Supervisors. I was kind of hoping our attorney would be able to speak. My name is Kurt Barthel. Okay. Barthel. It's not Barthel. Poverty Flats Ranch is a small family-owned and operated ranch owned by myself. I'm a retired Deputy Labor Commissioner. My brother, Robert Barthel, also known as Bobby, a retired City of Lakeport employee, and my sister, Jeanette Derry, who is a retired school teacher, especially high school. We have owned and maintained this working ranch since 1978, so we're longtime residents of the county. My brother Bobby has been a longtime resident in Kelseyville, where he raised his 2 sons. My wife and I also lived in Lake County for several years. During the time, I worked for the Sheriff's Department and later the Lake County Welfare Department, before eventually taking a position with the Division of Labor Standards Enforcement in San Jose. My family and I have carefully maintained the property with strong commitment to preserving the normal character of the valley. Over time, we've built positive collaborative relationships with our neighbors at the winery and further up the road. As we move forward with this project, we are dedicated to responsible land stewardship and investing our own labor and resources to bring it to life. We will make use of our existing well and access roads, both of which were constructed in compliance with CAL FIRE standards. To minimize our environmental impact, we plan to power the site with solar energy, which will support the well and security lighting with minimal generator work. Over the few years, my family plans to take on the majority of the work to establish an organic farm. We are committed to proceeding only with the proper approvals in place, including building, grading permits from the county and both Fish and Wildlife and Water Board. My brother and I have been environmentalists way before that became a word. We were way back in the 50s and 60s doing the work. There was mention by someone of the public law about law enforcement activity. This past winter, a drunk driver who appeared to attempt an impromptu road rally up High Valley Road, but missed a turn and launched over the edge. The incident prompted a response from the Sheriff's Department, Highway Patrol, Fire Department, and an ambulance. To our knowledge, this has been the only enforcement activity in the area since my family acquired the property decades ago.
We can wrap up.
Yep, approval of this project will provide my family with a diversified source of income, helping us financially sustain and maintain our property. We sincerely thank you for your time and consideration in the approval of this project. Thank you.
Thank you.
Hello, my name is Walter Canair. I am part owner of High Valley Oaks. We are the farm just north of the Barthels. I've known them for 7 years, so I'm here to voice support for them. I have a botany degree and also a forestry degree from Stevens Point. I'm a certified arborist for 17 years. I can answer any of your questions about the water. We are on the same ridge. We are totally different water that's down below. They have bromine. If you go through High Valley Valley, if you look at everything down there, their water looks brown like your water or your walls. Ours comes out crystal blue like your pitcher. We have the same size well. We produce this. We have a 125,000 square foot canopy. We mitigate it by weed mulch, which the Barthels, we're going to help them manage. We have no problem with water. We've never had problems with water. Good incidents of Bob this summer was someone lit an RV on fire. I was the only one on my farm at that time. I called Bob. I'm like, where are you at, Bob? He goes, I'm right down at the farm. I'm like, can you come up? I have a water trailer. I don't have my truck here. He ran up there. We hooked up our water trailer. We started putting out the fire before the fire department got there, and we stayed there until it was out. Those are the kind of neighbors you want. Thank you.
Thank you.
Good afternoon. My name is Richard Knoll. I'm a planning consultant from Lakeport. I am not consulting on this project. I'm not working for the Barthels. I have known Bob Barthel for many, many years. I worked with him at the city of Lakeport. I did submit a letter of support for the project and recommendation to deny the appeal. That's marked as Exhibit 239 out of 245. I hope the board has had a chance to read that letter, but I would like to emphasize 3 points. Number one, that the mandatory findings set forth in the CEQA initial study indicate that implementation of and compliance with mitigation measures identified in each section would reduce project impacts to a less than significant level. That's coming from your staff. Number two, the proposed project has submitted documentation, technical reports, and plans really costing tens of thousands of dollars in accordance with the county zoning ordinance in support of the project. There are considerable facts and information in the CEQA initial study which support approval of an establishment of the project on the subject property. The third point is that cannabis farm income, generation of county revenues, employment opportunities, and increased expenditure of employee disposable income within the county will all help enhance and maintain a healthy local economy and produce jobs. Regarding the appeal itself, in my opinion, the appeal is procedurally
Wrap up.
defective under Article 58, which states that the appeal has to be accompanied by a written statement
If you can wrap up,
indicating
please.
that there was an error made by the Planning Commission or that there was
Richard, if we
abuse
could wrap up,
of
please.
discretion. I don't see any specific reference to that in the appeal documentation. And that ought to be the first thing that is checked off when these appeals are submitted. Thank you.
Thank you.
Good afternoon, board, everybody, staff. Wes Baker. And I've been here before, but just background for anybody that doesn't know me, or there's some folks here that I've not seen. I was talked before on this subject, and Tom talked about it a lot today. Tom really nailed into it. A lot of research he did into that. The last time we had a talk about this project, I brought this up and was about that letter from BLM. And why I'm talking about that letter from BLM is that I've got a Juris Doctorate degree. I went to law school. I'm not a lawyer. I had a better deal from my corporate employer to go on and work with the general counsel than for me to ever do any kind of practice. So I didn't take the bar exam, but I did go to the law school. It was 4 years. 1 year of that was criminal. It's all we studied. We've got lawyers in this audience here today. They study that same 1 year of criminal. There's only 4 subjects you study in law school. You don't study CEQA, that's a separate thing. You do that after you get out of law school. In the criminal, for one major point is you can't indemnify a criminal act. You can't sign a document that says, you know, if somebody's going to rob a bank and they come to me and I'm Hertz Rent-A-Car and they tell me, hey, I'm going to rob the bank with your car and we'll give you the rent then after we rob the bank. And I say, oh, okay. And you can't indemnify that. At that point, there's what they call a conspiracy. There's what they call talk. We could talk about robbing the bank all day long and there's no law broken. Once we start to further it,
Start wrapping
in
up.
other words, give a permit or something like that, then the conspiracy is there. Once someone does it, then the act is done and it's criminal. The BLM has told
You
us
can
it's
start wrapping
criminal.
up, please.
It's federal. And we have to abide by federal law. You took an oath to do that. Everybody on this board. Thank you.
Thank you.
Point of order, Chair. This is supposed to be an appeal, and I think it's a bad look to have the applicant here when it's us.
Right, they were just sitting
Yeah,
there. I mean,
if-
they're not
if we're
going to
going to-
answer anything, so if
Okay. This is a point of order. It's not my public comment, but I think this is a bad.
they're not answering any questions from anybody. They just sat
Well,
there.
then I would
Unless
respect, if I may, just as a suggestion, to have all of us that aren't normally up here in the dais.
Okay, if it's fine, can the group exit back to the?
Another point of order, Chair. Are these comments 3 minutes?
Can you come to the? There are 2 minutes.
Mr. Chair, if I may.
Yes.
Point of orders are usually coming from your board.
All right.
That's under that's under Chapter 1 of the county's policies and procedures. Nobody else. So
I
just
understand.
for your chair's consideration.
Thank you for that. Let's come in a little sooner on the next one. Yeah, I'm fine with it for optics purposes, but they weren't up here to answer any other questions. That it was just a bleed over, if that makes any sense. Any other public comment?
Good afternoon, Mr. Chair and Board. Thank you so much, Margot Kambara. The appellant team appreciates your time and attention to this important subject. We did not finish all our presentation. What I want to provide is a summary. We have been told by the applicant that we did not present substantial evidence. Here it is in summary, 12 points. First, grading. Illegal grading destroyed the CEQA baseline in violation of Section 15125A, and the county removed the required complex grading permit from the MND, creating significant new information under Section 15073.5, mandating recirculation and invalidating the approval. 2, procedural, CEQA process. 2 materially different MNDs were used, one circulated and one approved, which is a textbook violation of CEQA's disclosure requirements under sections 15087, 15088, and 15073.5, and no agency may lawfully adopt a CEQA document that has never circulated to the public. 3, fire safety, PRC 4290. The MND illegally limits fire-safe road analysis to the driveway instead of the entire access route, violating PRC 4290 and CEQA Appendix G. And because evacuation feasibility was never evaluated, CEQA requires an EIR as a matter of law. 4, roads, federal land access. The project depends on access across federal land without a required right-of-way under 42 U.S.C. Section 1761, and BLM confirmed they cannot authorize cannabis transport. CEQA cannot assume an
can start
illegal
wrapping up, please.
access route, making the M&D unapprovable. Biological surveys were conducted before illegal grading and only on a fraction of the
Start
parcel.
wrapping up, please.
Well, the other things that we didn't cover is our rebuttal to hydrology, water, and septic. Hydrology conclusions contradict visible drainage channels and illegal trenching that alters flow, and without slope stability and downstream erosion analysis. CEQA Section 15064 requires an EIR because a reasonable possibility of significant impact exists. Solar infrastructure, cumulative impacts,
We can
BLM
start wrapping up.
identification. Solar infrastructure goes to the heart of fire. One more, just solar. The M&D conceals substantial infrastructure, including trenching labeled as, quote, fire suppression, end quote, despite matching site plans, which violates CEQA's whole of the project rules, section 15378, making the document legally inadequate. Thank you.
Okay. And just for clarification, Lloyd, no, forget it. I'll ask you later offside.
Chair Crandall?
Yes.
Given that there was one of those points that seemed to imply strongly that we did a bait and switch on our
Right.
CEQA document, we'd like to just repeat the dates of public circulation and assure the board that what was circulated publicly was what the Planning Commission used to base their decision. We do have those dates if the board would like us to repeat them.
No?
Okay.
All right. Let the gentleman, I don't think he got to speak yet, so then anyone who hasn't spoken, please come
This
up.
is James Anderson, attorney on behalf of the applicant. I just want to question as a point of order, are we going to have a rebuttal period? And that's at your discretion, I believe. Was that
Right. And again, I think Lloyd had stated that a point of order comes from this body. I'm just going to check in. Is everyone okay with not having rebuttals, or do you want to hear the rebuttals back and forth?
Well, I would say a rebuttal would be appropriate, but for a time, 5 minutes at most, 3 would be preferable, but no one is respecting our timer. And that's really frustrating.
I think it's important.
Supervisor Sabatier or Vice Chair?
Yeah, but maybe a hard cutoff or something.
Supervisor Sabatier, then Vice Chair.
I'm okay for something short, but I feel that eventually what we're offering is a ring for the appellant and the applicant to step into rather than inform the board. And I'm worried that right now that's what we're leading towards.
Vice Chair?
I'm okay with a short time rebuttal. Sorry, I am okay and agree with a short timed rebuttal
So
at the chair's discretion.
So what we'll do is let the folks that haven't spoke yet, and I see a gentleman that I think you were going to speak. I didn't know if you wanted to briefly, or if you want to wait for the rebuttal and be the rebuttaling.
I'll wait for rebuttal. It was just
Okay.
a question about that.
And then just for notice, Maria, if you can designate who your rebuttal is as well, so that we can do a 3-minute each rebuttal, in that once we're finished taking these statements. So, can you come to the mic, please? Go ahead.
So I'm a little confused. So we're presenting an appeal. They rebutted it.
No, they're asking to be able to have rebuttals because Lloyd had mentioned, and you all had mentioned too, a rebuttal, I've heard.
No, they did when Angie Dodd sat up there and gave her spiel about rebutting the appeal. All the things that we said, she said are bad. And now
Well, you also asked for like a closing statement or something like that. I think that's what it's really getting to, is one last statement. Is that what we're looking at, or
And how much time do we have for that last statement?
3 minutes
3 minutes.
each, just one on each side?
All right.
After public comment, we still have like 2 or 3 people that want to speak, so.
Okay, so at this time, we're opening public comment?
We
or
still
why-
we have been in public comment, and we're still waiting for, I think, 2 or 3 more people to speak,
Okay,
so.
so I'll sit down, we'll continue public comment, and then
Yes.
we proceed from there. Thank you.
Yes. All right.
Hi, I'm Charles Morris, and there's a few things that I heard here that it's a little bit disturbing. My only tie to this entire area is that when I was a kid, I was attacked by a mountain lion in that area. And maybe I shouldn't have been there, and maybe somebody was trying to tell me something, okay? And that is the fact that it's so important, the environment. We're all tied together by the lake. It doesn't matter where the hell you live in Lake County. And what disturbs me the most is this drainage. The drainage comes down in and it hits Clearlake. That's fine. But we have businesses on Clearlake that don't exist anymore because they get fined by Yolo County because of water that they're not allowed to take. And the only way that water can get there is to come down those damn hills. Okay? We're killing the environment and we're making excuses for whatever reason we'd like. I personally think that Yolo County should be involved in this because every time we grade something or we stop the drainage or we do something that takes away from the beauty of the land, we all know that the lake isn't what it used to be. It used to be a lot fuller. We had real islands. We had safe places where tribes had been forever. My minor in college was Native American Studies. I studied this whole entire area. I was the first graduate of the Native American Studies program at Sonoma State University back in 1990. I really have a hard time seeing how we're going to justify something when we clearly are not just breaking laws, we're breaking the spirit of the land and the people that have been there forever. And it breaks my heart that the tribe isn't here and they aren't saying these things. And I don't feel it's, I'm speaking for the mountain lion who hit me, who literally, tackled me and gave me a good bite on the top of the head. We have so much that we're doing wrong. Let's do better. That's all I got.
Thank you.
Yeah.
All right. Thank you very much. I just wanted to touch on a couple of points. The appellant identified in the beginning of their presentation that this is not about the project, and they went and commented on their opinions about a bunch of policies. This is about the project, and the applicant defending themselves have demonstrated that.
So, sir, you got to speak, and you're kind of rebuttaling right now, so we're trying to allow for people who haven't spoke yet to come up.
Okay.
If that makes sense. So if, just real quick, if there's anyone else that hasn't spoke that wants to come up.
Okay, I had 2 other comments if I can throw them out.
Throw them in.
Just fair argument that you could put 150 acres of grapes on this property and it would be principally permitted and you wouldn't have to allow all these conditions. And I want to identify on the BLM issue, there's 16,000 cultivation sites nationwide. There's all sorts of activities across federal roads, interstate highways. Permission is never requested, and it's no different than allowing cultivation or a distribution store anywhere. It's just not that big a deal. That ship has sailed. Thank you.
Good afternoon, Chair and Supervisors and County staff. My name is Bob Barthel. I'm a part owner of Poverty Flats Ranch. And I just want to say there's been a significant speculation regarding grading activities on our property, and I would like to clarify the facts. In 1922, we obtained a grading permit to widen our existing roads, improve their condition, install proper drainage. The work occurred after the complex fire and before we applied for this permit. Okay, during the road work, we asked the county whether we could push fire debris and down trees into piles without disturbing the underlying soil, and we received approval of that. And this work substantially reduced the fire hazard on our property. For the past 41 years, we have maintained property flats primarily by hand through controlled burns, brush cutting, vegetation management. In 2018, the complex fire came through, burned approximately 80% of our property. Okay, it was devastating, but it opened up our property. It was a brush pile. Okay. Anyway, over the past 7 years, we have focused on fuel reduction through cutting and burning fire debris, establishing fire breaks, reseeding and replanting trees, and installing erosion control measures to protect against runoff and soil damage. These efforts benefited the land and the wildlife. Our small creeks now flow into early summer, our springs remain full year-round, and the overall fire damage has been significantly reduced. As the saying goes, you can put out a brush fire, or you can put out a grass fire, but you can't put out a brush fire. Brush fire. Okay, so in the satellite images and unauthorized drone footage that some of you have probably seen, there's white spots. Okay, those are big white spots. Those are big ash piles from all the debris that we've burned.
Can we wrap up?
Okay, the property contains an extensive network of roads and fire breaks, and there is still additional fire debris to be removed as part of our ongoing mitigation work. I hope this clarifies the situation and addresses the false accusations that have been circulating. And I just want to add one more thing. When you take 3-foot-high grass and you mow it down, you get dirt. And that's what you're seeing on these satellite photos. Thank you.
Can we please stay to the 2 minutes? Like, we've covered a lot of these points already. And I appreciate that, sir. I know you haven't had a chance to speak yet. We ask you to please wrap up, and we continuously talk for another 40 seconds or 50 seconds. And just one more thing. I mean, we really need to stick to it. I mean, we've been going on for quite some time. Is there someone else that wants to come up and speak, please? There's 2 on Zoom. iPhone XR.
Skywaywa, Pillsbury Family Farms. And I just hopped onto the Zoom call because I just popped in, and from my understanding, Lake County had a really hard line for the water board and the well being registered by 2017. And what I'm seeing is that deadline is not being respected, right? I hear a lot from all the different supervisors wanting to protect the waterways, caring about the neighbors. But the real cold hard fact is if their well was not registered and did not have their well tested in that time frame that we needed it done in order to be a cannabis approved project, we all need to honor that.
Thank you. Did you want to
just clarify? We did cover in our presentation, perhaps Ms. Lewa missed it, that the well was installed by permit.
Okay. Supervisor Sabatier?
Yeah, just to clarify, she's talking about the water board permit from, forget the title of the...
Notice of applicability?
Just, we have a deadline of, I think it's October 31st,
That's a completeness item, so I'll
2021.
give staff a minute to just confirm, but typically it doesn't get past our pre-application
Yeah.
meeting without that.
Yeah, just wanted to at least prove or not prove that that is there.
Yeah.
There's another person. Donna, if you can unmute.
Good afternoon, Board. Donna Mackwitz offering comments on information not yet presented. The peregrine falcon and other birds covered under the Migratory Bird Treaty Act have been observed and not mentioned. The bald eagles also has protection under the Bald and Golden Eagle Protection Act. Both species retain some state-level protections, with bald eagle being fully protected under California law. The bald eagle and peregrines have been observed on site, and there's been no nest surveys conducted by professionals, and the discussion on the Clearlake hitch spawning habitat has been omitted. Hitch historically spawned in Schindler in huge numbers, and we recently were awarded BRC Blue Ribbon Committee grant that will be addressing this for the Schindler Creek tributaries, which begin up on this parcel. It's a $3.2 million grant that will address the hitch spawning. And thank you for taking my comment.
Thank you, Donna. There's no more hands in Zoom. Okay. And so, yes, we'll have the closing remarks or rebuttal, if you will. It'll be like a slash. If you want to make your last 3 minutes to be a rebuttal, fine. If you want to make your last statements, use this 3 minutes to please do so. And whoever would like to start.
The appellant has procedural matter first.
Yeah, normally it's us.
All right.
Want to make sure you're okay.
All right. So, Lloyd.
Yes, your board has the option of having the appellant speak first on one rebuttal and then allowing the applicant to speak his rebuttal / closing comments afterwards.
I just want to make, if I may, is it okay? Yeah, this is more of the rebuttal. And first of all, I think this has kind of gotten out of control. But what I would like to say as a rebuttal, there was a statement made on the BLM that, you know, roads from the county is okay for casual use, and that's just true. However, commercial activity is not casual use. I would respectfully refer to the document we sent after we received their document on rebuttal. And you should have received it yesterday. You also have the presentation. I would also point out that the comment about not having substantial evidence. Well, that's not correct. Substantial evidence includes responsible agency input from the CHP, measured physical conditions, photographic evidence. We've also had credible observations, video recordings, other measurements, comments not from consultants, including Ms. Dodd and including the other gentleman who mentioned in other hearings that the road needs to be measured. The bald eagle has been sighted. Unfortunately, we haven't gotten to that. Ms. Makowitz was there when it was sighted. They tried to question whether, you know, who knows what an eagle looks like, but I'm pretty sure we all know that she knows what an eagle looks like. The comment from Mr. Knoll saying that we didn't have anything that would suggest that the Planning Commission that there was some reason that there was an error in the Planning Commission. The significant amount of prejudicial misconduct that occurred in that meeting is sufficient to warrant the permit to be sent back or denied. You can't have a fair hearing if people are omitting information. The indemnification agreement was not in the MND. It is not okay to have it hidden in back documents. And then finally, well, not finally, but on the grading, the letter we have from CDD shows that Mr. Barthel, and I apologize for mispronouncing his name earlier, at the same time he was talking about cannabis, he was talking about grading, and he blamed the grading on CAL FIRE. So he had full intention to have that grading. The aerial imagery taking immediately after that email was dated shows significant grading already performed. It was blamed on not CAL FIRE, but fire responders. We show all this information. You have the slides. Unfortunately, we're not able to get through all of them. You have all the documentation. We have substantial evidence that shows that this permit should be denied and the appeal upheld. Thank you.
Thank you.
Afternoon, Board. James Anderson again on behalf of applicant, and with Everview Law, we specialize in environmental law, land use, natural resource law. I've been before you many times, and I just want to address some of the litany of legal issues that have been discussed here today in no particular order, and then I'll try to finish up with my general thoughts about this project. So I guess in some sense this is a rebuttal, but also a closing statement. First of all, appellants make several references to the fact that the MND didn't analyze certain documents such as an indemnification agreement or BLM access routes. Those aren't subjects to be analyzed under CEQA. CEQA is focused on the environment, not lawful access, not the internal politics or agreements created by the county for cannabis applicants. So that's the first point. Second point I have is that the appellants frequently and systematically refer to substantial evidence in the record that they have technical experts that have commented on this project. That's not true. They're taking comments out of context for different projects that were located in High Valley from a different time with different project components, with different project operations, with different vehicle types, and all sorts of different aspects, and applying them to this project, and that in itself legally cannot be substantial evidence. And I just want to return to the fair argument standard more generally. Angie, in her presentation, referenced this and put up a slide that, as far as CEQA is concerned, the appellants are required to show substantial evidence or substantial evidence supporting a fair argument that there may be environmental impacts. Substantial evidence is, in fact, a defined term within CEQA, and it consists of facts, reasonable assumptions based on facts, and expert opinions. It cannot be hypotheticals, it cannot be speculation, it can't be argument, and it can't be non-technical opinions on technical matters such as hydrology, traffic safety, certain biological aspects, slope stability, geology, things like that. And a lot of the comments that come forward are technical comments from non-technical members of the community. So I think I want to take a step back. I know that I only have 3 minutes. I'm going to try to respect the time and look at this more broadly from Lake County. I've been in these chambers a number of times in front of you about a number of projects, and I've participated in the update to the cannabis ordinance, and I've heard your board grapple with projects before and the cannabis ordinance in general, and I know a lot of these projects are appealed. And what I hear generally time after time when I'm here is your board struggling with what projects the county needs to approve. I think it's clear at this point that the county has accepted that cannabis is going to be part of this community in this county, and you're trying to determine where it should be. This project is the model project for the county. It's presented by locals. It's a small project. It's miles away from any other sensitive receptors. It's far distance from any nearby residents. There's really nothing in this project that would lead me to say that you should disqualify it. And in fact, everything that I've heard from you over the years would indicate that this would be the model project that you should approve. So I want you to take that in consideration. Thank you for your time, and I appreciate you taking all the time this afternoon on this appeal. Thank you.
Thank you. Yes, well, I'll close the public input of that.
Chair Crandall, if
Yes.
I may, I would just like to add to the record that I absolutely and vehemently disagree with an accusation of prejudicial misconduct. I am very confident that the behavior and activities of our staff have been well within compliance of our zoning code and our general plan and our best management practices and any other standard that would hold us to a very high professional standard.
All right.
Thank you.
Thank you. As requested, Supervisor Owen would like to take a quick break. So let's take a quick break, and we'll be back at
Chair
4.
Crandall, just, Mr. Chair, if I may, just so to confirm with your board, public testimony, public comment has been closed.
Been closed, yes, sir. Thank you. Thank you. I need that big time.
I know, I needed some sugar. Some sugar?
Oh, no, I'm okay on that. I got it. All right. Welcome back from the break. We are going to continue on with this item. And we had closed public input at that time, and Community Development Director had made a statement. And we're back at the board for comment and action. I don't know who's first.
I don't think anybody knows who's
I can.
Go ahead.
I'll start. I did spend a significant amount of time reading all of the documents that we received to include public comments, not only this week, but previously when we had this hearing set to go before. And I do appreciate everybody's concern and for what they think is appropriate. But where I'm at with this is, our job as the board here is to review this project and make decisions under our ordinance of Lake County regarding zoning in these projects. And there's a set of criteria for that. I'm not going to go through them all, but I've got them here in front of me, and that's what I'm trying to focus on. And I see this project as being a small project that's got a low impact actually on the environment compared to other ones that I've seen in the past. So in all of my review and looking at everything, I feel like the project fits for this location for many different reasons. And I'll stop there for now.
Supervisor Sabatier?
Thanks for breaking the ice there, Vice Chair. So I appreciate all the comments. I wish they were a little bit more towards the topic rather than arguing about arguing just for the sake of arguing. I think so. I want to touch on the documentation. Massive numbers of PRAs, emails being put out, potentially taken out of context. And I'm looking at staff, and that makes it really much harder because your intentions are to do your job, to come in here and follow directions that we provide, and then your words kind of get used against you. Unfortunately, it's also a learning moment of sometimes we just really need to be careful about everything we do. We live in a very digital world, whether we're walking outside or whether we're working on our computer. Everything is being recorded, and there's emails in there where I don't think there was malintent, but I could see how it could be taken out of context and used in a way that says, look, there's prejudice. And that sucks because I've been there. Same thing has been used against me. And it's not a fun situation. So I hope that you're able to navigate through those troubling waters because that's not fun. There are, and I disagree. I think that the appellants had arguments. They argued about the road. They argued about fire. They argued about certain things. I think that makes for a legitimate appeal to a project because those are legitimate things that we should be reviewing. I don't agree with the far majority of what the appellants were offering. I think that everything looks good to me except for one thing that I struggle against, and that's the scenic corridor. And again, I'm going to stay consistent with past behavior and future behavior until this changes. In our scenic corridor, it says you can only do 5,000 square feet of ancillary or processing facility, and there's more than 5,000 square feet of building that will be put up. I don't understand how that area of High Valley is still a scenic corridor. It is not highly traveled. It's not a highway that brings people to our community. So it's there, and I can't delete that. Again, same thing as what was mentioned by Vice Chair, is staff is working on the ordinance while I have to work with what the zoning code is specifically. I can't ignore what it is. And that's my one struggle. I haven't necessarily talked myself out of it, but I know that this has been a conversation I've had with past project applicants. Is there an opportunity for a waiver for these types of things? Because I can't say yes to one thing and say no to the next when the writing has not changed within the scenic corridor ordinance. I have to at least apply it appropriately. If there was a waiver, am I allowed to ignore that if there was such a thing? I don't know how I feel about that, but I feel like that is a difficult bridge for me to cross without anything else in front of me when I know that there seems to be about 7,000 or approximately 7,500 square feet of building that will be erected based on this project, and it exceeds what the scenic corridor states. And so that's my one line where the law says certain something and we seem to be ignoring it because we have this internal policy that's not in writing that we're following that we have yet to ever approve. And I'm not willing to ignore the fact that the writing on the wall says such and we have to follow what it says, not what we intended to do. So talk me out of it, help me out, I don't know, but that's my bridge that I'm struggling to cross over.
Did you want to?
Yeah, I do appreciate that point. And I was thinking that in the meantime, before we are able to do that proper consideration and analysis and presentation of a policy for going forward, what we would enter, and I'm sorry I didn't think about it for this presentation, but initially is in subsequent presentations where any part of that parcel is within the scenic combining overlay, which wasn't part of this project, but given the concern at the board level, we'll start adding visual representations of the impact of the project on the county road, or what would be visible by the public. That might be a helpful tool in going forward, particularly for projects that are located well far from the historic application of a scenic combining overlay.
That would work. And if you have proof that it's not even visible, then again, I think a waiver again, because I can't just vote against something that's written. A waiver would say we are waiving this part of the ordinance in order to allow for this project to happen due to the visual evidence that we've provided. And at this moment, I don't have that.
We do not have a mechanism particularly for a waiver specifically. Relief from development standards or through our deviation. So we can consider adding that to a project should it seem necessary in the future. But thank you. Your concerns are definitely noted.
Supervisor Owen?
Okay. Well, I'd like to say, I guess I should turn on my mic. I'd like to say that there are a lot of things I do like about this project. Part of it is the location. And I think that this is kind of the area I would like to see us growing in. However, I do have some questions. Are the roads 4290 compliant going in and out? The road going in and out, is it?
You mean the roads outside of the project parcel?
Yes, yeah, going to it. That was one of my concerns.
The county maintained road part of it, I would have to defer to Lars, our public works director, who actually just left.
Okay,
Right.
so that is one concern, because we know we're bringing stuff forward to make sure that because once you go commercial, we do need to have the 4290 road compliant.
And we have clear nexus to require that within the control of the applicant, but not outside the control.
But we still need that, right? If you put in a commercial business, you still have to have 4290. You need to be 4290 compliant.
The planning
Not
commission.
in ag, but in, if I put in a store, I have to have 4290 compliant if I'm considered commercial.
I have no doubt that Caltrans would love all of our roads to be 4290 compliant.
Mm-hmm.
I would again defer to Public Works regarding the plan for roads improvements.
Okay, so that is one issue I do have with it. The other issue I have, which I didn't think of, and I don't know why I didn't till somebody had called in, and that is my understanding was that there was a moratorium on cannabis unless you had your water resource permits from the state prior to 2017. Is that different than what?
Sorry.
Because this was drilled in like 2022.
The notice of applicability document required in order to proceed from pre-application to actually submitting an application, one moment, I have it, is from October 20th, 2021, I think, October 31st. And the notice of applicability for this particular project was actually issued in 2020. So they're well within the deadline.
Okay, with that, it states that the well was drilled in 2022? Or how did they get their water?
People drill wells with well permits all the time.
Sure,
It's
but
not
I thought that you had to have your water approved for cannabis. I'm probably wrong on this because I'm new on the board, but as I understood it, I thought we had to have the water approved back in 2017.
The well permit, as testified by the applicant's team, was for an agricultural well or an irrigation well. Sorry, my mom's calling. And it was not specific to use for cannabis. So.
No, but there was documentations back when they were doing the botanical environmentals back in 2020, so we knew that that's what it was going to be for.
Reports done in preparation of submitting an application would necessarily have to precede the application.
Okay,
So a hydrology report asking for, to establish well criteria would necessarily have to.
So they are not, are you understanding what I'm asking?
I did want to help out a little bit. Yes, the original expiration date, I believe, was, I think it was April of 2017.
Yeah, the board moved.
Then we eventually amended that because it was a hard cutoff and we felt there was a way to reopen for more application at that time. I believe we may have even changed it twice, one to 2020, then it somehow disappeared, and then we brought it back again to be 2021. So October 31st, 2021, you had to have your water board permit of sorts. I don't know if it's well related or that, I don't know what their process is. But it was through the water board that you would get this permit, that if you had that, you could apply. If you had it prior to October 31st, 2021, then you could apply for a cannabis license. So some people had it way back in the day, depending on what their ag uses were, and if maybe they already had a water board permit. Other folks got it much later, and some people are trapped and did not meet the expiration date and are not able to apply it.
So I'm just confused how they could get a well permit, water permit, when the well wasn't drilled till 2022. I just want to make sure we're legal. That's what I'm looking for, is legalities.
Let me make sure that I'm clear and that we have a clear differentiation between a well permit and a notice of applicability from the State Water Board.
Do you have that dating back prior to? Okay.
Yes, they were
All right,
compliant.
so my interpretation of what was required is different than what the actuality is then. So next, let me get my glasses back on. Okay, now the other thing I'm having a real hard time getting past is I don't believe, because we've been allowing something illegal, that we need to continue allowing something illegal. And there's not one, not two, but I think 4 letters from the Department of Land Management, the Department of Interiors, from 4 different people stating that that it's not okay to go over the public land or their lands, the federal lands. So there's 4 different people on that I'm concerned about, and that's something I'm not convinced that it's approvable, that it's legal. I thought I saw a letter in there from the Department of Forestry, but I couldn't re-find it. And then Dan Franzler with the CHP had mentioned that he had concerns about the amount of traffic on the roads, per what was in our documents.
So I will defer to County Council regarding the interpretation of driving over federal lands. CHP.
There was a letter from Dan in there.
Okay, I'm sure we would have taken their input under consideration. However, there's the amount of traffic was pretty clearly delineated in the project. So I'm not sure. We usually rely on that input if a traffic study, if the impact to roads has managed to affect a traffic study. I don't think he required a traffic study for impacts on roads under CHP jurisdiction, which would be Highway 20, not even High Valley.
Yeah. So those were my comments.
Thank you.
That I have concerned.
Oh, when you said 4 people addressing the road driving.
From the interior, yeah, 4 different letters.
4 different letters.
Yep, 4 different letters from the interior, what did I state? From the Department of Interiors, Department of Land Management.
And is that in our project documents, or is that submitted from the appellant?
Yeah.
Okay.
There was Nicholas, and I'm going to butcher the last name, but it's LAVR. I think it's KOV. I wrote it real sloppy. There was a Craig, there was a Cooper, and then there was a Bantez. It looks like number 8, number 9. The attachments.
Oh, in the attachments submitted?
Yes.
Oh, okay.
Number 8, number 9, number 10, and I think 11.
We're going to take a moment and
Maybe
look at those.
13. I'm just looking at the number 14.
But also, I would still defer to county council for further
Okay.
clarification.
So there was like, I guess there was more than that, but I think some of them had done multiple letters.
Lloyd, did you want to add? Or?
Yeah, thank you, Mr. Chair. Just briefly, so what's before your board today is the, granting, denying the appeal, either in whole or in part. That is, the basis for granting or denying the appeal, just sort of as a general summary of it, will be based on the major use permit findings for approval, right? It goes through certain categories. I believe it's 1 through 8 to start, along with the recommendations. That's located in pages 17 through 21 of the May 22 staff report. I believe that's attachment A. That was submitted to the Planning Commission. So in particular, your board certainly can take in whatever evidence that your board deems relevant in making a determination on whether or not it supports a finding or does not support a finding. On that specific issue, on the road access, I would think that would be finding number 3. That's on page 18 of that Planning Commission staff report, where it says one of the required findings is that the streets, highways, and pedestrian facilities are reasonably adequate to safely accommodate this specific proposed use. So your board has discretion to take in the evidence in order to make a decision whether or not to grant, deny the appeal, or grant in part or deny in part. That being said, the same staff report does make reference, it's incorporates by reference. It's dedicated under page 6, a section on federal lands crossing, makes reference to the indemnification agreement. That's been referenced here in the course of testimony that was presented to your board. And I would like to direct your board's attention also to the major use permit, which I think is also attached. Major permit conditions, that's under this County of Lake Major Use Permit document, that's Exhibit A2, in which general condition number 2 expressly states that this permit does not abridge or supersede the regulatory powers or permit requirements of any federal, state, local agency, special district, or department, which may retain a regulatory or advisory function as specified by statute or ordinance. And the applicant shall obtain permits as may be required from each agency. General condition number 3 also states that prior to operation and construction, the applicant shall obtain permits from all necessary federal, state, and local agencies for the construction/development of any infrastructure. So that's also made, it's attached as an exhibit, that's also presented to your board for consideration for your board's purposes of whether or not to grant, deny the appeal in whole or in part.
Additionally, we do have the letter that pertains to this project, but the other letters are for other locations.
Did you have anything else?
No,
Okay.
I'm researching it.
Lars I don't think he is.
He walked out. Not too
Yeah, he walked out, so. Nope. Okay, well, did you have anything, or we ready to?
I mean, I'm ready to take action.
All right, I will just briefly say that, just real quick, because I know that I got frustrated through, so I wanted to make a statement for you all that I know there's been an overabundance of compelling arguments, and, we appreciate your time and energy. We understand how passionate this is. I apologize for my curtness and frustration. It's just trying to keep this meeting in order, trying to keep some tact and some order for this meeting to move forward. And at times, I understand that there's passion, so people are trying to put one up another here and there. But we really need to just understand that at the end of the day, we got to make a decision. And I don't want anyone to feel as if I'm making a decision based on that, because it's not. And I appreciate your tact and candor. So, did you want to add or?
Yeah, I do. I don't like where I am, and I was listening to what County Council was saying about somewhat approving in part rather than just saying straight out no, because I agree with everything that Vice Chair mentioned, that this is a suitable area for this type of work. But once you get past the 5,000 square feet of ancillary buildings or processing, that's when you cross the line in the scenic corridor. I'm willing to say yes, and that you can't go past the 5,000 square feet because that's the law that we have. And when I'm looking at the site plan, I see a 2,500 square foot, I see a 2,400 square foot, and I see another 2,500 square foot. And so I would say, in part, I'm willing to say yes, but we need to figure out how to deal with the scenic corridor, or they need to figure out how to repurpose their project so that it meets the guidelines of scenic corridor, because it doesn't. Because I'm not willing to ignore the 500 foot.
The 500-foot
setback that we create.
Right. Okay.
And I'm just wondering how the board feels about that. Because again, I want to help us get to a yes. I don't want a no. There's been a lot of work. I see no other issues with that. I'm stuck on the scenic corridor.
How far away
Can
was
I
this
ask?
from our scenic?
Yes, Vice Chair, please.
Do we have an exact square footage on the, I know my colleague mentioned 5 or maybe 7,000 earlier. So I want to make sure I'm fully understanding what the actual square footage of structures is. I'm not sure I do right now.
I'm looking at the
Certainly
site
we can
plan
get
and I
that for
see
you.
3 2,500 square foot ancillary nursery greenhouses and 1 2,400 square foot processing building.
Slopes. We are taking a look at that 500-foot buffer, and staff will measure how far out exactly that is. Best we can offer, since I don't have a visual representation of the impacts, is to also note that this is as the crow flies, not the visibility from all the nooks and crannies of the hills and the slopes too.
And I apologize, but I just want to clarify, my issue is not the 500 foot. There is no 500 foot setback. That is something that is internally created, but is not within the ordinance that we've approved as a board. And so I can't approve of a setback that doesn't really truly exist until we've done something to the scenic corridor. To me, it's the scenic corridor ordinance says no more than 5,000 square feet when it comes to ancillary buildings or processing. Here we have 7,500 plus 2,400, so we're above what is allowed in a scenic corridor. There is no 500-foot setback, and we've talked about that it's an internal thing that has been created. The board needs to approve these things. We can't just create setbacks.
Mr. Chair, if I may.
Yes, please.
A number of years ago, this issue did come up for a project that came before the Planning Commission, and myself and the staff in community development at the time did an extensive research as to where the 500-foot setback actually had come from. There is the scenic corridor section, Article 34, I think it is, in the zoning ordinance, and it does provide the criteria within the scenic corridor section, but I think, or designated scenic corridor. I think the issue here is where is the designated scenic corridor, and that's what we went looking for. In the specific area plans that informed the general plan, at various times they were adopted by specific areas, and those committees, I assume, that helped adopt the area plans actually identified scenic corridors for their specific areas. And they put those scenic corridors, they designated them on specific numbered maps that community development keeps. If you were to take a look at those maps, there is an actual highlighted section for each of those maps. Some area plans specifically state 500 feet from the road, and some areas actually went through a great deal of study and made study as to sort of visual impacts for specific areas along roads, and made an inconsistent sort of setback depending on how their visual study ended. So it wasn't a straight line on the map. But there are maps that were informed by the area plans adopted by the areas, adopted by the county, in part of informing the general plan, that do designate scenic corridors and the setback areas. Community development could provide those maps to your board to show you where in the specific area that a particular lot is located, what that area plan identified as the scenic corridor, but they do exist. And generally speaking, in more than in the majority of the plans, it was a simple 500-foot setback, but not in all of them. So if that helps any to clear up where the 500 came from.
That is the best explanation I've yet to receive, so I appreciate being in the room today. I am going through the scenic corridor portion of the Shoreline Communities Area Plan, which I believe is the one that we would be looking at. But I greatly appreciate greater guidance than I've received yet on where it came from rather than just this internal process.
All right, did you have something else?
No, that as County Council has mentioned, the Shoreline Communities Area Plan does list High Valley included in potential scenic corridors, but it does not list specifically the distance of the buffer.
And then Supervisor Owen, you have your pen up?
Oh, I'm sorry.
Okay. So at that, this is in my district. If someone would like to either make the motion to deny or approve.
I'll make a motion.
Okay.
Mr. Chair, at this time, I'd move that the Board of Supervisors deny appeal PL 25-198 in concept upholding the Planning Commission's adoption of initial study IS 23-29 and approval of major use permit PL 2568 for UP 2329 and direct staff to prepare draft findings of fact.
Second.
Lloyd?
Yes, thank you, Mr. Chair. So, point of correction, the reference to initial study IS 23-29 should be 23-20. Is that correct? And as part of that motion, so that would be the correction, part of that motion. And also, as part of that motion, that the motion would be based on pages 17 through 21 of the May 22, 2025 staff report, which is attached as Exhibit A.
So I'll modify my motion to include as amended.
Or just so moved.
So moved.
Incorporated.
Second.
Supervisor Sabatier, you had something before I take the vote?
Just a brief discussion, and I am not asking for the chair to divulge which direction he is planning to go. I just want to put it out there that as motioned, I cannot approve. We were just told there's not a 500-foot setback. I'm willing to look at less than 5,000 square feet in order to get to a yes. At this moment now, with this motion, my response is a no. Just want to make sure that you guys are aware, because I'm not sure where it's going. I have an idea, but just wanted to put it out there before.
Do you want to amend it, or do you want to move forward? All my questions have been answered. I appreciated and was concerned about the cultural artifacts of it. I know that especially with the grading that occurred, that was a 4290, which is exempt. Unfortunately, I've dealt with that before. It's frustrating as it is. It's what it is. They had also stated, they being the applicant, had stated that they were going to have a monitoring agreement with Mr. Amoda. So to me, that remedies, and as long as they keep that promise, that's important. That's a very important aspect to it. The road, they said they would use box trucks. That satisfies that area of it, and I'm pretty sure I don't have any other choice but with my questions than to support it. So, I mean, if that's the way you want to go, unless you want to amend your motion. Well, we have a motion in a second, so I might as well just take it.
Leave it.
All right, so I have a motion in a second. All in favor? Aye. Opposed?
Nay.
Motion carries 3-2. All right. Thank you.